June 25, Flathead Reservation Water Management Board meeting. Welcome to everybody online. If there's anybody online, anybody in the public, welcome. Volunteers for an opening prayer. George, would you like to give us an opening prayer today?
You bet.
All right, thank you.
Okay, let's pray. Dear Lord Jesus, to you. Thank you for this gathering of fellow board members. Help us to make wise and careful decisions. Bless us all. May we all have a good day. Protect us and guide us throughout our lives. In Jesus' name, amen.
Amen, George.
Amen.
All right. As always, meeting minutes are on the Flathead Reservation Water Management Board.gov website. So if you need to see those, please go there. And any potential conflicts of interest on this agenda, Ken?
No.
Or
No.
Roger?
No.
Georgia?
No.
Okay. Attendance, please.
Clayton Mack,
Here.
Roger Miller,
Here.
Georgia Smees,
Here.
George McLeod,
Here.
Ken Pitt.
Here.
Absent today is Shane Henderson.
All right, thank you. Agenda, so if you've had a chance to review the agenda. When you're ready, we'll take a motion to adopt the agenda. If there is any questions or changes, please let us know.
Mr. Chairman, I move that we adopt the agenda for the June 25th.
Motion to adopt the agenda.
I'll second.
Second by George. All in favor, say aye.
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 Any opposed? None. Public comment for items not on the agenda, so any members of the public have an opportunity to comment. Anybody online?
If anyone online would like to make a public comment, you can raise your hand and we'll allow you to speak.
Mr. Chairman, Joe members, I will, doesn't look like anybody else is online looking to raise their hand, but I, did get a call from somebody who wanted me to, offer verbal public comment for them on their behalf. Anthony Pierce, who had written an email previous, to the board requesting to have a complaint procedures move forward. Did call me earlier today. Anthony would have attended in person, but he had a work commitments. And did want to urge the board to move forward with some kind of a complaint situation that would help him with this resolution, citing that he's got 9 cattle that don't have access to water right now. So I said that I would pass that on.
Thank you, Ethan. Any other public comment? Nobody online?
No one online.
Seeing no other public comment, there'll be more opportunity later on in the agenda, so we will move on. Number 3, adoption of forms. Speaking of complaint, we have a complaint informal 609F. So who has this?
Yes, please. Okay. Just a quick clarification on the agenda, please. There's a slight mistype. So the first form that we're going to look at is the 609F, which is the formal complaint, and 610 is going to be the informal complaint. So we just have those 2 numbers backwards.
Okay.
So starting with the formal complaint.
Yeah.
So I believe that you actually saw a draft of this.
That should be the formal one.
Now that we have the WP&Ps that have made it through the public comment period, we're showing it to you again for your final approval, so we can activate it. You'll notice a $55 filing fee, which tracks the DNRC's filing fee for their complaint procedures.
Mr. Chairman, board members, as as a bit of a clarification, we have under item 3, the adoption of these forms, but item 4 is actually the adoption of the procedures, and so, those two activities would need to happen hand in hand, and, after our last meeting, we did have confab to determine exactly where the board left things between the priority discussion and the discussion about complaints. And we were unsure as to whether or not the board wanted to proceed with activating the complaint procedures. And so that is why items 3 and 4 are in front of the board today, so that we can firm up where you wanted to go with this this item. Thank you, Mr. Chairman.
So we are on 609F.
We are
correct?
609, that's the formal, so
We paid, that's that, it's two.
So
Yes, yes, and it also may help, Mr. Chairman, board members to realize that the form numbering mishap happened because DNRC does have an existing complaint form for which they have a fee associated with it. And they do not have a formal and an informal form. And as we proceeded along the pathway, the board requested an informal complaint form, and we added that, and then it wasn't really until we were kind of doing some final proofing that we realized that we really wanted to track the DNRC formal complaint form, which is 609.
609 is the DNR's complaint form.
And so this small correction is because in that big scheme of things, we got our numbering a little off from what the state uses numbering runs. I hope that helps.
Actually, okay, 609F. And then what is listed here, it says 610F.
Yeah.
Should it be an F or not?
Yes.
I should. But even though it says F, it's the informal complaint.
609 is the formal.
610.
Oh, 610 is the
610, so to help clarify what you have,
610 should be F or no F.
all of our forms should
Okay.
have it.
Okay.
So you might just explain why they have an F and why that's flagged for even for the database use.
Yeah, so the reason that we put an F at the end of all of our water right codes, I guess we call it, is to clarify the difference between our forms and the DNRC.
F for the flathead reservation.
Exactly.
And like at the last meeting, I think part of the virus thing was that if there was a issue with virus, having the F after it allowed them to flag a problem. And then-
It's all, yeah,
Yeah.
it's all having the same system.
so,
All right, 609F. If you want to finish reviewing that, I think what I'm hearing is that unless we have other comments, suggestions, or changes today, we've reviewed it, it's gone to public notice. And did we get comments? Maybe you said that already. Did we get comments on it?
So on, later down in your agenda, on the part that did go to public notice, which is the WP&P sections, I don't believe we received any public comment on those sections.
For the complaint procedures. We did, the complaint procedures have undergone a full 15-day comment period with no comments that happened in February, is that February, I think it was? And
Were the forms part of that?
That, no, the forms do not go out for public comment.
Okay.
The forms do require the board to approve them.
Right.
And that would need to be a unanimous approval, as with all of our water rights forms.
Okay,
I have a question.
question, go ahead. Birgit.
This is just a question to satisfy my ignorance. It's not a problem with the form. But on number 3, I was just curious, based on this office and others' experience dealing with water use and water rights, how much of an obstacle do you perceive that it can be for someone to actually have to call? You know, for folks to have to talk to each other before they call you. Is that? I know it doesn't say in every case you have to in most instances, so I know you've built in some leeway there, but is that a big deal?
Mr. Chairman, board member Sneeze, it is a common situation where, when there's a little bit of discrepancy over a water issue, maybe folks who are sharing the source, the ditch, the right, would rather, work through an office than through each other. And, that is, on here specifically because our office for certain actions, may require that the water users actually try to coordinate in advance of us interjecting. And so, for instance, if you will, is that if somebody's not getting their water and they are just jumping to the complaint phase instead of making call, which means requesting a junior water user to curtail their use if they are senior, then we would maybe say that that's actually step 1 before our office comes into some sort of enforcement complaint resolution action.
Thank you. That's very helpful.
I got one other question,
Roger.
and it may have been addressed previously, I don't recall. But on the second page, way at the bottom, it says it has to be signed, original signatures. Is there, anymore, there's electronic signing, you do DocuSign, you close on a property and all that, are we gonna go that way ultimately, or, I mean, it's legal nowadays, so,
It's not used by the courts.
okay,
You need original signature.
really. All right, well, that answered.
Yeah, and Mr. Vice Chairman, we've struggled through this a little bit. It is a little harder for folks who want to just send us an email copy of something. But because of the declaration and because we did go away from requiring notaries on a lot of these forms,
Yeah,
we are currently at a stage where we think wet signature is appropriate, but obviously we work at the direction of the board.
no, I think Ken made a valid point. If it's not used by the courts, then we can stick with an original signature.
So the IRS will take an electronic signature, but we won't.
They do have alternate ways to double check the submission
That's true.
that we perhaps don't have
That's true.
here in our office. So we have a lot of reliance on the signature as a declaration of the accuracy.
And crossing T's and dotting I's, the attorneys have reviewed this and blessed it.
Ms. Haley, would you
Hey, Haley.
please say hi and answer the chair?
Hi, afternoon, everyone. I guess could I have the question repeated so that I'm 100% sure I heard it correctly?
This is Clayton and, as I said, just crossing T's and dotting I's, these forms you've looked at.
Yes, yep.
Okay. So following on the signature question. Is it one complaint, one form? Is that the,
Mr.
what's
Chairman, board
intended?
members, the intent here is, one complaint, one form.
But you have the option of two signatures at the bottom of the form?
Mr. Chairman, there may be multiple, water right owners that wanted to sign onto the same complaint.
Okay, so we have two, and if we need more, there's a way to add more, 3, 4, whatever.
That's our intention, Mr. Chairman, and so, you know, there may be some need to tease out whether somebody is filing more than one complaint, but if the subject activity is consistent and you might have multiple people complaining about that same consistent activity, our office would accept multiple signatures on the same complaint. And in fact, you know, I could see someone filing a complaint getting some benefit from having multiple signatures on a complaint from multiple water users on a source complaining about the same issue.
So it's not one complaint, one signature.
It's like one subject of complaint that may be made by multiple people. So,
And 3 different water right owners?
yes, and if I could try to give an example that may help my lack of description here, Mr. Chairman. So if there is somebody who has blocked a ditch significantly for one reason or another, like, you know, and multiple people down ditch complain, and they could all sign onto that same complaint about this one blockage. So the blockage would be a single, you know, complaint subject topic action that has multiple people signing up to complain about.
So they all split the filing fee, or they all have to pay their individual filing fees?
In this case, we would accept just a single filing fee. The way they decide to parse that out amongst multiple people signing is not so much my care.
Other questions? So before we take action, we'll do public comment. If you're ready for us to take action, are you ready for us? Ready?
Yes.
Georgia?
Sure.
Roger?
Yeah, I guess you brought up a good point though, Clayton. I guess I never thought about that. I would have interpreted the signature part as if there was on a single water right. If it was a husband and wife's name, then they would both sign the thing to be a legal filing. And I would have thought that if there were other parties, they would file an individual
Their own
complaint.
complaint.
Yeah, their own complaint.
Would have been my thought. Haley, you reviewed this and you heard the conversation. Any thoughts on that from a legal standpoint?
Yeah, I mean, typically procedurally, it would be how Roger described it. So because if there's, let's say, 2 separate water rights, typically those need to be dealt with, you know, separately, although they're alleging maybe the same issue that the other water right holder might be alleging as well. And so, yes, they might have the same issue that they're bringing up, but typically they're dealt with separately as like separate filing parties.
Well, and just to build on that a little bit, you know, you asked for a lot of specific information on the point of diversion and all of that, and there's only one POD that can be put in. So I guess I would suggest or recommend that we limit this complaint form to one party. To make it cleaner.
And I will just make a clarification on the forms too. Any and all forms can have extra pages and additional pages added to it. There are notations of that on every single form. that you can provide additional sheets if you run out of space. So, although there might be a couple, or limited space, it does not prevent somebody from submitting additional, pages.
So Ethan, based on the conversation there, your thoughts now?
Mr. Chairman, board members, I am happy to, handle this in a limiting fashion in which, the complaint, an individual complaint, must be filed by, separate individual water right holders. We can even add a line to that effect if that's the board's wishes.
Might it be simpler to amend the complaint procedure rather than the form? So
Yeah, that would have been my take.
back up.
Should we address the policy, not the form?
Mr. Chairman, the forms themselves do not actually need to go to public comment. It is the procedures that, went out to public comment. A couple of things. One, I do believe you could make changes at this point to either of those and still move forward with them. Because you did go to a public comment, but it doesn't mean that you have to necessarily adopt the complaint procedures as they were put out to public comment. You can still make modifications to the complaint procedures or these forms right now. So I don't think you need to hold yourself back on making any changes to either the forms or the procedures. We can make those changes if needed. If the board thought that the changes were so significant that it, really modified things, and maybe you wanted to have another public round, you could also do that. But I hope that I'm helping on how things could proceed. And also happy to either modify the procedures or the form based on what your preference is.
Okay, so we don't need to modify the form, you need to modify the procedure. Question is this a substantial change? And I kind of think it is.
Well, what did the
Well,
procedure say?
Well, yeah, because I think what we heard is Ethan's verbal description of how he would administer that. If it is the board's preference to do it different. Do the existing procedures allow that? And if they already allow that, then maybe we don't need a change. So let me ask this question because I wanted to circle back on this a bit. Let's start with this. Is it the board's preference to go one water right per complaint or to allow multiple water rights, multiple individuals with separate water rights to file a complaint on the same form? So, Ken,
One water right per complaint.
Roger.
Yes,
Okay, so now let me ask this. So you got an individual, Roger, who has 3 water rights. Same individual, 3 water rights, wants to file a complaint. So does that individual then need to file 3 complaints? Roger.
so let me throw out a scenario that could happen. I perceive that most of these will be surface water related. And that somebody's got a ditch and they're a downstream user and they're not getting their water. And so they they put in there where they're trying to take the water out of. So then they're just gonna really have one point of diversion, but they may have more than one point of diversion on that water right, although that's pretty unusual. So I would say it should probably be limited to the individual filing the complaint. And not just the water right. And I mean, if he has multiple water rights, but that's, that means he's got 3 points of diversion down that thing. So, but he's affected by all the same, he has the same effect by the person he's complaining against. But it's a cumulative effect rather than a
Okay.
individual impact. So I'd say one complaint form per individual. If he's got more than one water right, he can list his multiple water rights.
And that makes sense.
Yeah.
To me, okay, so. Now, the question is, and Haley and Ethan listening to this, do the current policies and form allow us to manage it that way? Or do we need to make a change?
If you look at paragraph 1 of the procedure. It says. Illegally using water to the detriment of a right to use water. The complaint possessor may file a complaint. And I think that covers exactly what you were saying.
Okay,
So I don't think we need to change at least paragraph 1.
Ethan, Haley?
Yeah, I mean, I can speak to that too. Ken pointed out exactly what I was gonna say. The procedures already, limit it to a person. And so that's singular, and then it's to water rights that may be affected. So, yes, keeping it to a single party, for the complaint form is fine.
Okay, based on that, my understanding is that's the board's preference. I don't know that we need to take specific action on that, but we've indicated that that's our preference. So at this point, if you're ready to take action on this, I'll take public comment. So Roger now.
no, I just think that we utilize this form as we discussed.
Okay. All right. Any public comments on this form?
Fish on the well. How much water is pulled out of the well?
We're talking about, that's okay.
I'm sorry.
Hurry up. No. So we're talking about form for formal water use complaint 609F. We have been discussing. We are prepared to take action on it, but before we take action on it, we would like any public comment on that form if you have any.
I have to.
If anyone online would like to make a public comment, you can raise your hand.
And do we have a copy of a form we can hand in? Have you seen the form? Okay. And it was the board's discussion and preference that we would allow one individual to file a complaint per form. And an individual may have multiple water rights. Multiple individuals would have to file their own forms. Okay, no other public comments, so we'll close a public comment on that, and board ready, we'll take action to approve 609F formal water use complaint.
Mr. Chairman, I'll move to approve the 609F formal water use complaint.
Motion by George, second by Ken, so I'm gonna go boys.
Yes.
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 Yes, George?
Yes.
Yes, Roger?
Yes.
Yes, and I'm a yes. All in favor? Thank you. All right. That puts us to the next form, I believe, correct?
Correct.
610F, the informal complaint form.
Chairman, board members, next on the agenda is 610F informal complaint. This is a pared down version of the complaint form, does not require a filing fee. It allows someone to make an informal complaint to our office to inform us of a complaint that's been.
So is number 3, location of water use complaint is the location of the party filing the complaint or the location of the party causing harm?
That'll be the location that the complaint is about.
Party causing harm.
Yes.
Okay. And if it's just, you might want to guide people when you hand this out, because if I get this and I read that, I might put my own on there.
Yeah, exactly.
Just a thought. Other comments, questions, concerns about this form? Roger.
Explain to me why we have this for.
So I believe that this form was intended to allow people who don't have water rights specific to the complaint to be able to file generally about water uses that they feel need to be complained about. So if you wanted to complain about water use that you noticed, but you don't have necessarily a vested interest on the same point of diversion, you could use this form.
I guess I would ask the attorneys, if they don't have a water right, do they have legal standing? I mean, this is kind of just, I don't know what I would call it, tattling on your neighbor or something, but to me, there's no fee, there's no basis. I don't know why we have this form.
So are you directing that question to?
Yeah, to either Haley or Ethan, I don't know.
Mr. Chairman, Mr. Vice Chairman, if I may, as a reminder, the board did instruct us to create an informal complaint form to have as an addendum to the formal complaint form. There were more reasons than what James was describing. Some of the reasons that there was a desire to have the informal complaint is that maybe somebody wanted to see if we could just touch base with somebody who's operating and to try to keep any kind of escalation conflicts lower. This informal complaint might be used for folks who have a hard time overcoming the $55 filing fee. This informal complaint might be able to be used to sort of encourage some dialogue to resolve things before having to have hearings and a more formal complaint arrangement. And also, I believe, Haley helped remind me, but in an informal complaint process, we don't necessarily need to, there's not a hearing that a notice of a hearing that goes out that identifies the individual filing an informal complaint. Identifying the individual who files the informal complaint to the person that they are filing the complaint about.
Are you directing that question to Haley?
Yes. Did you hear me?
Yes, I did. I just wasn't sure if you were mid-thought. Yeah, I mean, so I want to clarify this a little bit too. So in the procedures that were sent out for notice and comment, there is an entire informal process that was put into those procedures directed by the board because the burden with formal complaints is very specific in the ordinance. For formal complaints, it is only for wasting water or for illegal use. But any other enforcement of water use is not essentially considered, and the ordinance is silent on that. And so that was where the need for the informal complaint process arose, was for that. And because there's not an informal complaint process within the ordinance, the determination was to come up with this process where it did not have a fee associated with it. And it was a less stringent process, which does not include a hearing, like the formal complaint process does, and does not result in the engineer drafting a findings of fact, conclusions of law, but rather an order on how to proceed.
So you're touching on one of my thoughts is, or questions is, the difference between formal, informal complaint and the responsibility that it imposes on the office.
Right, yes, okay.
Yes,
So
And-
the formal complaint is a legal procedure. And the informal is pretty much just notice that there's something going on that I don't think is right. And that establishes a record, so you can staff, maybe talk to the people. Conveys, I don't even think standing is a part of that, it's just, example, I have a creek going through my property, I fish on your lawn, I don't have any water rights, and suddenly it's dry, I'll set it. What do I do? I mean, you're right about the informal, but you actually have to stand on it.
so back to the purpose of an informal complaint, is it primarily just for documentation?
Yeah, I think else, I always believe that people deserve to have their day in court, per se, and this provides an avenue that somebody can actually say, yeah, we saw something that we think is wrong. And we want someone to take a look at it, so they're able to do something.
So we'll have a specific procedure for formal complaints, and the office will have certain responsibilities. There's a notice and a hearing. Informal complaints, how do you see informal complaints working for the office?
Mr. Chairman, board members, what we anticipate is that when an informal complaint is filed with our office, we would generally review the nature of the informal complaint, perhaps couple that with some interview questions with whoever is filing the complaint, and determine generally whether first and foremost, it's within our jurisdiction to be interested in this. B, kind of priority wise to determine whether or not we think there's some sort of a water right enforcement action that may resolve the item being complained about, and then C is kind of fitting that into our budget of staff and time and priorities. In contrast, when we get a formal complaint filed with the office, we go right into sending out notices of the hearing, which is, we're going to do that regardless. There is certainly an initial first review of the formal complaint to look at items like standing and sufficiency of filling out the form accurately and helping us to determine whether or not people have met the requirements of the formal water use complaint form. But assuming that they've jumped through all of those adequate to process steps, then we go right into having a notice and possibly field investigation items.
And the informal complaint procedure, if you look at it and have a discussion and talk it through with people and they resolve it, that's one thing. But if it gets to the point where the office has to actually engage, how do you see that happening?
Mr. Chairman, board members, it's tough to predict all of the scenarios. I think
Yes.
that they would be varied. And so that, along those lines, I think what we would do is kind of engage based on the type of complaint that it was. If it really seemed like a clear-cut water right enforcement issue, we would have to make a determination as to whether or not how far we would proceed down that path of resolving things informally before we would require the person filing the complaint to up their complaint to a formal complaint. And I do believe that would be one of the potential outcomes of trying to find resolution on an informal complaint, is that our office and our staff might hit a level where we say, okay, we think you really just need to file a formal complaint because this needs, to go to hearing.
If all the criteria are met.
Yeah,
So, regarding the formal complaints will know about those, the board will know about those. Is it anticipated that the board will know about informal complaints?
Mr. Chairman, board members, your direction previously, about our water right application, documents that you see every month, you had requested that we would provide you, a column in that, documentation that would include, complaints received. And I have every intention of, having, informal and formal complaints, in separate line items, that will be reported to you. Furthermore, Mr. Chairman, board members, I do believe that, it is useful to have the documentation of an informal, complaint should our office decide we're going to do something like investigate.
Yeah.
Use some time.
Yeah.
Maybe even some field investigation and whatnot. I would like to, because you have, a fair number of other priorities for this office. I do believe we need to have some level to justify, spending time and effort, on any kind of, investigations, like along those lines.
Well, it's kind of in my mind where I'm headed, is that hopefully the board can monitor that and help you. Because I think that if we establish an informal complaint procedure, which I realize the board has said we should do that, is that I could easily see lots of informal complaints coming in, taking up lots of time. And if it gets too carried away, we might have to back off of informal complaint procedures, or change policies, or somehow help regulate that. I'm just thinking out loud here, but those are my thoughts.
If I can, Mr. Chairman, board members, I think that, some of these may be as simple as someone complains about, there's somebody dredging dirt out of the well, and we can easily say, well, that is not our jurisdiction, and write a brief letter to that effect, and you can go talk to the Army Corps of Engineers or ALCO, and that's resolved. But,
Yeah, I get that. I'm just thinking about volume.
And as you set policy, you always have the ability to modify policy as needs arise.
And I think you're still gonna get a lot of complaints. It'll just be over the phone, have someone stopping in instead of a piece of paper.
Yeah, and I think if I recall our discussion, I think we largely wanted to create documentation of those. Whether we can do anything about all of them or not is gonna be the question, but I suspect there's gonna be a number. And maybe that'll taper off over time, but anyway. Roger, any more?
Yeah, just clarification, maybe a question for Haley. So Haley, I've heard two different scenarios in this discussion. Can an informal complaint escalate to a hearing?
In a way, I think I would frame it more so as the informal complaint could escalate to requiring a formal complaint to be filed. And so the Office of the Engineer would direct that complainant to file a formal complaint under the proper form, to initiate the proper process and notice of hearing.
Okay, thank you.
All right, any more on that form, Ken?
I see it as a useful tool to the O&E and to the staff to, they could do some legwork ahead of time, something that might turn into a complaint.
Okay. Thank you. Georgia?
I agree, and I don't think this is perhaps the desired objective, but I think it's a great tool to not only gather information for this office, but to give a heads up to other entities who do have the authority to do something about it. They may not otherwise be made aware. The example you gave of dredging in a wetland, to be able to contact the tribal wetlands office, I think they'd like to know about that. Otherwise, how, they don't have a way of finding out, so I see benefits to this.
Roger?
Yeah, I echo some of your concerns about the amount of staff time these things could take, and that's my reticence. And I guess the other thing is, if you can make, somehow I think this form does need to be modified so that it's the location is described as the violator's location, not the.
Yeah, just to make that clear, yeah, because that was, yeah.
I can make that change.
Okay,
I'm not comfortable with the word violator.
well, I
Yeah.
think, but it gets to what my question was, so it says location of water use complaint. Does that mean for the name of the filing party or the name of the person causing the harm?
You need an identifier there.
So if it's for the person causing the harm, somehow tie it to that one.
Location of water use of party causing harm.
I'll just say location of water use. Let's make sure.
Causing-
That is,
Sorry.
location of water use that is causing harm,
Yeah.
which feeds off of item 2.
Yep.
Is, if that's okay. With my mind.
Okay.
So.
All right,
interrupt you.
are we ready for public comment? Yes, yes. Okay, public comments.
I would use the word conflict.
Hmm. Would you like to make a formal
Well, I would,
comment? If you would, come on up and,
oh, no, I.
okay, we're just, this is a public comment opportunity, so if you want to make one, we'll have you come up and, okay. Anybody online?
Chairman, may I say something? I like the conflict. It's nonpartisan.
Well, before we approve the form, let's settle on the exact language then, so that we can, so they can get it on there.
Yeah.
So,
Conflict just
let me,
says there's a conflict.
let me
Doesn't say
finish the
harm.
public comment section here first. Anybody online?
If anyone online wants to make a public comment, raise your hand, we'll allow you to speak. Seeing no public comment online.
All right, Ken?
Again, I would like to see the word harm, change to conflict.
So let's be specific about, let's read it.
So item number 2 would say name of party causing conflict.
So you like it, George?
Yeah.
Georgia?
Yes,
Roger?
I think that's a lot better.
Okay.
Item number 3 will say location of water use that is causing conflict.
Okay. All right, with those changes, no more, no, there was no public comment on that. With those changes, if you are inclined to approve it, we'll take a motion to approve.
I'll move to approve Form 610F informal complaint.
Hold on.
I saw one typo in here. So under important, you have 609F.
Oh,
Yes, that is correct. Formal complaints are 609 now.
Okay,
Informal complaints are 610.
okay.
Okay, so back to the motion.
Move to approve Form 610F informal complaint with discussed changes.
Motion by Ken,
I'll second it.
second by George. All in favor, say aye.
I
Aye. Any opposed? No, okay. Thank you. We are on to 611F.
And Chairman, Board, the final form of the day, which is the objection to an application 611F. Slightly different from the complaints. This is an objection to a proposed application. This is mirroring the DNRC form 611, and it mirrors their filing fee of $50. The time that this form will be used is when a water user applies for a larger application, one that goes under public notice. And this is going to be filed for by a member of the public who's objecting to that
new usage law. So you'll see in item 2, we would use this on permits, change in use authorizations, uses of the flathead system compact water, the enforceable flow schedules, and the protective wetland applications.
Is that just, excuse me, is that just protected wetland? And then number, that number is separate, right?
That number is separate, gives you a little more space right there.
It says, do you have standing to file this objection, yes or no? And if the answer is no, should that be the first one then? Should that be number 1?
If no, okay, I like
And if
that.
no, then they can't go further.
Go.
Oh. If no,
No, and
proceed, yeah.
Okay.
What's that, if no, proceed to, makes sense?
If you're gonna put it first and you're gonna say, go home, you better put that in the explaining language. Like, so it says, you have standing if your property, blah, 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 is absolutely, that's, if you do not have standing, do not fill out the scope. Or something, just.
That would be my, I mean, something up front would, if that makes sense to you, then yeah, I would think that if that's a threshold they have to cross before they can file it, then yeah, we should do that.
You may not file an objection.
So I have that right there underneath bullet point number 3, it will say, if no, you may not file this.
How do you define the word interests? In that sentence,
Interests, where do you see that?
under what is now number 3. A person has standing if his or her property, water rights, or interests would be adversely affected.
Is that, sure.
Mr. Chairman, Board Member Spies, an example of that would be if you had a group of people that, and I'm just gonna give you a hypothetical example, a group of people that were in stream flow advocates. And they thought an application, and this is a hypothetical from the real world in the past off this reservation. But they could make the case that they have interest in in-stream flow, so although they do not own an in-stream flow water right, but they have interest in in-stream flow water rights and water not being owned. That would be an example.
So can I resort to my former self? I'm not real comfortable with that definition. I mean, the fact that you want water in a river. And you don't have the legal right to, you just want something, like, I don't see that as conveying standing.
Well, and it ties to the question of do they have, you have standing to file objection, yes or no? So that implies if they just have an interest, they have standing.
I think it's not so much like, I mean, the term interest, they have different meanings. In this case, I believe it's more than just like, oh, it's piqued my curiosity, or, you know,
Have the word legal interest.
Well, I think the DNRC requires you to have a water right if you're gonna file an objection.
they do not. And this does mimic as,
Because
like, so Trout Unlimited has
they have water rights,
in the past that they have objected to things.
Yeah, they have. but I don't know if they're given legal standing at a hearing in that case. I think the DNRC is pretty, I mean, if you have a creek and the water's running by your creek and somebody wants to use that water and that's gonna say, oh, this is affecting my aesthetics. That's not much of a basis to file an objection, so.
Haley, on this form for standing to file this objection, yes or no? How do you interpret the word or the phrase or interests? How it applies to that?
Yeah, typically that is seen with a public entity. So for example, I mean, Ethan brought up like Trout Unlimited, but there's also like Forest Service, for example. There's a public trust interest. And so there is that ability to object in that circumstance, even though they might not own a water right that's being affected, but their public trust interests might be.
So someone could fill this out, not have a specific water right, believe they have those kind of interests. And if we determine that that meets the criteria, then we can proceed. If we determine that it does not, then we reject it.
Correct. Yep, it's a pretty standard evaluation that almost any judicial body or evaluating body has to evaluate right at the beginning. Because it's the ability of a party to bring an issue in front of the deciding body.
Mr. Chairman, board members,
Ethan.
for what it's worth, I'm just, Googled the DNRC form number 611. Item 3 on that form, we have pretty much, just plagiarized that phrase from the current state form for what it's worth.
What does it say?
It says, how do you have standing to file this objection? Ours says, do you have? But it says a person has standing if his or her property, water rights, or interests would be adversely affected by the proposed appropriation. And then it says, explain your interest and how it would be adversely affected. Ours does say briefly instead of explain.
Okay, Georgia, you raised the question initially. You good with it? You have more questions?
Well, I understand it better now.
Okay.
I'll leave it there. I
Yeah,
guess.
Ken.
I'm not good with it still.
Okay,
I think you need to insert the word legal interest. The fact that DNRC doesn't mean it's binding on us.
you can we can add what we want.
Yeah.
Is that something you want to ask Haley
Sure.
about?
Haley, I'd like to add the word legal interest to it.
Yeah, that's fine. I'm comfortable with that.
All right,
And just as a side note, and it's nothing to do with what we're talking about. The Forest Service traditionally has not recognized the public trust doctrine applies to it. I've litigated that.
Oh, really?
Yeah.
Interesting. Huh. I don't even know what that
The
is.
Forest Service does have filed a lot of in-stream flows though, and so they do have legal
They
standing.
do have legal standing.
Yeah.
Mr. Chairman, board members, just to circle back on item 3, I currently have to insert the word legal in front of interests and to also add the sentence, if no, comma, you may not file this form. Okay, I want to make sure that I capture everything. The only other change that I had prior to that is under 2, where the number is, we should put application number instead of just number, so that it doesn't look like protected wetland number.
that help, Georgia? Okay,
I agree.
Yeah, so those are 3, I have now a count of 3 items that the board has identified, regardless of your action or not, that we will modify on the form.
Haley, I asked a question.
Ken.
Has this form gone out to public? Okay.
Mr. Chairman,
As we talked earlier, I think none of the forms went to public comment, just the procedures.
Okay. Okay.
and for what it's worth, we have had a lot of internal discussion. We don't believe that the forms need to go out to public comment. It does not, however, eliminate the board's option to request public comment on things. So we don't want to, we don't think it's a requirement, but we also are not trying to guide you away from that if it's the board's choice to solicit as a comment.
Good with that?
Yes.
So if they file this form and how are you gonna go about determining if this is a valid objection?
Mr. Chairman, Mr. Vice Chairman, generally, I believe that, we'll need to, out of the OE, do an assessment to determine whether or not we agree that the objection filer has standing. Based on our conversation today, we'll probably make some internal policy clarifications about standing, because I felt like we had some discussion about legal interests that maybe it would be beneficial for us to make additional clarifications, possibly in the WP&P, that help our office, make those decisions about what is or is not a legal interest that agree with the board's directives. So, past that, we will look up the water right number, see if it's a legitimate water right. We will check the physical setting to see if it's potentially affected by the proposed action. And that said, if they meet the general, in my past career, if you could just generally meet the criteria of the objection application form, you usually got a hearing.
Yeah, and I guess that's where I'm going. I've never seen an objection go to a hearing that didn't have a water right associated with it. So even though DNRC has this language, I'm wondering if we're in copying their language, if we are being overly accepting of things, when you have a water right, the first thing you look at is adverse effect. And they have to demonstrate that. Haley, am I out to lunch on that?
I can't really provide specifics, but I have litigated that exact issue. And it did involve two entities that didn't have any water rights, and they were allowed to proceed in not only a DNRC administrative hearing, but also the Supreme Court of Montana.
Okay, all right. But usually that's the first threshold, is if you have a water right, so. Okay.
Ethan. On Page 2, third paragraph, so where the star is, be sure to fill out portion applicant, and it says attach the corresponding findings of fact with your objection. Who's finding facts of what? Ken, that's the third sentence where the star is.
Oh, thank you.
What do we? Which finding of facts are we talking about? And let me add to that, because then you go down to the bullets, adverse effect, diversion works, beneficial use, possessory interest. Each one of those says provide facts. So are those the same facts we're talking about? Are these the finding of facts that you provide with the application? Is it the finding of facts of the person filing the complaint? I'm just not clear.
Yeah, Mr. Chairman, I think it would be, I think it would be good to delete the words finding of.
Yeah.
And say you must attach the corresponding facts with your objection.
Facts being what?
Just the. So sorry, Mr. Chairman, I'm looking through this too. Right.
Ethan, do you want me to help provide some clarity on that?
Haley, please.
Yeah, so, I agree. I mean, I think the findings of fact, language that's in that asterisk could be changed. But essentially what the provide facts means is the information that the objector would need to provide to the office in order to assess those specific criteria.
Okay.
So, yeah, it's their burden to provide that information to the office, not the office to find out what those facts are.
If that could be clarified there, that would be helpful. And does that same concept apply to those bullets below? Adverse effect, diversion, beneficial use, possessory interest?
Yeah, I mean, I think that's very clear in the bullets to provide facts. I mean, the way it's worded, it's the onus of the objector to provide facts.
Okay.
So I think the only thing that would need to change would be that use of findings of facts in that asterisk above A.
All right, all right.
What if we remove findings of facts and inserted documentation? I mean, isn't finding of facts kind of a legal term?
It's very conclusion.
Yeah.
Yeah, I mean, I was almost just gonna say, just take out findings of and keep facts in there, and so the corresponding facts. That is what they're supposed to be providing, but facts, information, documentation, that those all can be interchanged.
Well, if you say attach the corresponding facts, if you're attaching something, that is documentation, that's implicit, but we could be more explicit if you need.
Hmm.
Mr. Chairman, Mr. Vice Chairman, we could instead just eliminate the word findings and replace that with documentation. Which then would say, you must attach the corresponding documentation of facts with your objection.
So, sorry, I actually need to step in here because, that's my mistake. I should have caught this. It's actually referring to the document that they're objecting to. And so it needs to actually be the determination of the engineer, which is what is made. Cause an objection can only come after there is a determination from the engineer. So if there's a determination to grant, that would be where an objection could be filed. And so essentially what it's requesting is that the objector files or attaches, like physically attaches the determination of the engineer to its objection form so that the office knows this is the, determination that they're objecting to.
So, and when I first read it, I thought that was the other option I thought this might be. So with that, then my question is, if we're filing an objection to an application, if the application is on record, includes the finding of facts, why does the objector need to then attach the finding of fact?
Because the applicant may be omitting facts that may be relevant. And I'm kind of.
Well, but the finding of facts are determined, as she said, by the engineer.
Yeah, but why would we have findings of fact and all we have is an application?
You don't have findings of facts at that stage yet.
Yeah,
You would have a findings of, well, you'd have a determination.
To grant,
Recommended decision to grant or recommended decision to grant with conditions. Because you wouldn't have an objection phase unless this office hit the RD phase and went to notice.
so you and Haley are saying if I file an application for a new water right. And you didn't want it, you would have to wait until the engineer made a decision before you can.
so you bring up a really good point, and for the board's benefit. So what happens with this form is the applicant comes in with the application. And it's got all the support documentation. The OE reviews it and sees if it has any deficiencies or not. Once they've determined it doesn't have any deficiencies, then they'll move ahead with a determination to grant that application. At that point, then it goes to public notice. And there's, I don't know how long the public notice is, 15 days, 30 days. But then that advises the public they can file the objection, and that's when the objection gets filed.
So you have to have a recommended determination.
Yes, it won't even go to public notice without that.
With the rationale that if we were gonna recommend a denial, there's nothing to object to. Because that proposed use won't make it past that,
Then the applicant might object.
which is an appeal.
Go
So
back to the
can we,
drawing board.
between Ethan and Haley, so given that, I understand that now. Can we make sure the language on here is clear? So that, I mean, if we don't do that now, we're gonna have to do it, come back, so we.
Well, Ms. Sharon Board members, what I'm gonna suggest with this form, because I think that this is an important phrase, and maybe I'd like to look at maybe a better way to help explain it here is, I don't wanna step on the board's opportunity to take action on an item, but this form is specifically in your package. You haven't seen this form before. It will be needed eventually for any kind of issuances of flathead systems, compact water, or new appropriation permits or change in use authorizations. Some of these things might be coming faster than others. I've already got, 4 things that need to be modified. If you'd like, we could bring this form back to you with those so that you have a cleaned up arrangement. But again, not trying to, I don't think it's gonna actually set us behind on actions in this situation. It would possibly be different depending on what you do with the complaint procedures and the complaint forms that you just moved. But with this one, we could come back to you with the cleaned up version to address your excellent editorial suggestions.
Which words, you wanna take the time to clean it up now and approve it, or you wanna have it brought back?
That's fine with me.
All right. And then Haley and Ethan, you'll consider the discussion we just had on that one sentence.
Yes, Mr. Chairman, I also don't want to slow down any other considerations for subs A and B or 6, 7 and. if
Changes,
the-
yeah. So let's finish our review. If there are any other changes, we'll note them and then they can make those corrections when they bring it back. Question. Ethan, Haley, individuals filing this, we may get to a situation where an individual water right holder wants to file an objection, but they hire a hydrologist, an engineer, or a technical specialist to do that for them. Does this form account for that, or do we need to account for that? Because it asks if have a lawyer, but whether or not they're allowed to. I'm reaching here a little bit because you may run into situations where some business or entity decides they want to hire a technical person or a firm to actually file it for them on their behalf.
I think that's captured in number 7. To allow for another person to prepare the form.
Well, I have a question.
Ken,
I'm not objecting to it, just how we should maybe briefly discuss it. Subparagraph A, the bottom line, water quality. Is that a legally legitimate reason to object to a water quantity application?
good point.
That's extremely important. I get that.
I think that's a good catch, and I think that this should actually say, provide substantial credible information to show that the water quality of your, excuse me, that the water quality of your existing water use will be adversely affected. And the reason I say that is that there is specific language in the ordinance on the criteria that a new appropriator can't adversely affect the water quality of other appropriators. But
I would cite that section of the ordinance because that's going to catch a lot of attention.
Yeah, maybe. And that has got to be Georgia's favorite part of the ordinance.
It is, because that would kick in for the flathead compact water, which specifically states water quality has to be considered.
Mhm. Haley, any thoughts on that one?
No, I mean, it is a specific criteria that's required for all permit and change processes. And then also other processes which involve a determination from the office of the engineer. So it is very specific. I will note with Ken's observation that water quality in this sense in a water rights application is completely different than a water quality analysis wholly within a actual quality evaluation, similar to like what the DEQ would do or what the tribal department would do.
I see question marks over your head.
No,
there, Ken.
I'm comfortable with these explanations. I just think if you're gonna put something in there that's topically controversial, you should have a cite to the ordinance. Yeah. Like that's-
Sounds good. Thank you.
And just to clarify, as I guess I want to clarify that, so we know how to edit this properly. Ken, are you looking for a citation that's separate from the one that's already provided under A?
I don't know, because I don't have it right in front of me. If that's adequate, I'm happy.
Okay,
What citation are you talking about, Haley?
under A, there is an asterisk that says for each item that is checked on a separate page, provide facts explaining why one or more of the criteria in ordinance section 22102 cannot be met.
Okay. All right. So if we're have someone separate filling out the form and say it's a technical specialist, then under 8, it says only an objector whose signature appears below will be allowed to participate. Can that include the person filling out the form and or the objector or both or one or the other?
So it would have to require the signature of the objector, the water right holder. I don't think there's anything precluding this also signing, but.
Well, and then it says will be allowed to participate in administrative hearing. So would the technical person be allowed to participate in administrative hearing?
Not unless they disclose them as an expert.
So somehow we want to make sure we're clear, we make that clear, Roger.
So that then kind of begs the next step of the process. So once Ethan gets these objections, and if he determines that they're a valid objection, then they'll schedule a hearing. And if it's a private individual, that individual can represent himself at the hearing, but if it's an entity or a company, then they have to have legal counsel to do so. But then like when Haley was saying, once all that gets gelled in, then they will submit their expert witness reports and whatever, and they can draw on those expert witness to participate in the hearing.
Okay,
Mr. Chairman. Haley, should this clarify that if the water right or property where the water right is being affected is in corporate interest, that they would be required to have legal counsel?
That can most certainly be put on there. It is in our procedures. But yes, if you want to provide that information on this form, that's perfectly fine.
any other points of question, comment, or concern with this form?
I'm a little uncomfortable with this as in an administrative hearing, especially if it goes beyond administrative hearing.
So what do you suggest and what do you want to do?
I'd say any necessary hearing. That's not so good.
Do you require hearing?
Yeah, I like that better.
Any required hearing?
Yeah,
Should we make it clear that we're talking about a hearing at the office of the engineer? Or So we're not trying to act like we're gonna impose on something that transcends that administrative hearing, or is that, go without saying?
It kind of goes without saying, but I don't know that the general public will understand that. Because the judicial hearing is part of the process. And they do have a right to that. But you can't participate in a judicial hearing unless you've exhausted your remedies administratively.
I also think that if you wanna put on, you know, in a minute or in any required hearing before the office of the engineer. Is probably more appropriate, because once it goes past that, it's not up to the office of the engineer to determine the jurisdiction. It would be the board next on appeal. And so it'd be the board's prerogative to determine whether they could participate further.
Does that language help?
Yes.
Okay. Good, thank you, Haley. More comments, thoughts, questions on this form? Roger? Roger? Okay, since we're bringing it back, we'll take no public comment and we'll take no action on this one today. Given that, I think we're moving on to policy. Let's take 5. Or 10. So we'll take a quick break. We'll be back. If you're online, we'll be back. All right, thank you. We are back. So we are on to item number 5. 5.1, so
Item number 4, Mr. Chairman.
item number 4. Yes, I knew that. Item number 4, so Ethan, let her rip.
Excellent, Mr. Short, excuse me, I'll try to get the mumbles out of my mouth, Mr. Chairman, board members, for your consideration. We have the complaint procedures. As a reminder of where we're at with the complaint procedures, the board had undergone a pretty extensive edit and review process for the complaint procedures. Then directed the office to put that out for a public comment period. There were no public comments received. Then we kind of sat on this for a little while. We discussed it several times, and if the board will allow, Mr. Frakes, if you could bring up that other document. We discussed at our last meeting the priority document, and this was the, you know, the document that came out of the committee, the priority strategic plan committee, excuse me. And we did, and the board discussed, you know, item 5 in particular. After that meeting, staff try to do some confab and figure out exactly what the correct move was for us regarding the complaint procedures. And we determined that maybe the board hadn't quite sorted out where it wanted to go with the priority of the complaint procedures, and give you this opportunity here to either direct us to adopt and move forward with the complaint procedures, or to wait for some other option as directed by the board. So that introduction is supposed to help you kind of frame where you want to go with our priorities, and then also give you the opportunity to take action and implement this, or set it on the shelf at your direction. I don't want to give you any confusion. If you do implement these complaint procedures, we will receive complaints. And so I don't want to give you the illusion that you would perhaps take action on this and approve these without seeing some noticeable activity immediately in this office as a result.
So these went to public comment as they are.
Yes, sir, that is
So
correct.
based on that, then I'm just gonna start with this question. Your opinion and Haley's opinion, are these ready?
Mr. Chairman, sorry, go ahead. Haley.
Oh. Nope, I was just gonna say that there needs to be just, some corrections to the, form. Because I believe they were changed after we sent these out to public comment, so I think we just need to double check and make sure that the correct form, designation is throughout these procedures, but other than that, substance wise, yes, they're ready to go.
Mr. Chairman, Mayor,
Yeah,
on page one, the numbers are mixed up.
Yes, and Mr. Chairman, board member Pitt, unfortunately, we didn't recognize that miscommunication between the state's numbering system and ours until right ahead of this meeting. Otherwise, we would have tried to address that issue without overcomplicating the discussion. Apologies for that, but we will diligently make sure that our form numbering schematic is correct, and if the board so chooses, we can ignore that issue in terms of edits that you'd offer at this time.
so I realize we approved this to go to public comment. But could you tell me what a temporary use complaint is? Ethan or Haley or both?
If there's a complaint about a temporary use of water, there is specific complaint procedures in the ordinance about temporary uses. Haley, would you like to add to that?
No, I mean, this is, specifically within the ordinance, it is, for the exact, action and type that's in the name, temporary uses of water. So what is included in 3 is almost verbatim language from the, ordinance.
All right, thank you. So this is as Ethan said, a complaint about a temporary use. Now, temporary, remind us, is a temporary use something that falls under the category of the other objections that we just approved the forms for?
Mr. Chairman, are you asking if somebody could apply for a temporary use?
Well, if somebody can apply for a temporary use, does that become a water right in such a fashion that these other forms we just approved apply to that, or do we need another form?
Yes, so the formal complaint, would be perfectly fine to use with the temporary use complaint.
Thank you. And a temporary use, remind us, is like for firefighting? There may be others.
Or a short-term lease?
Do we have an application for that sort of a water right?
Mr. Chairman, board members, the short-term lease, I think, is more specifically in relation to the tribe's water right and covered under the compact. It's a little different than the ordinance level use of water.
Was that your question?
Yeah, I
Or,
guess.
or were you asking, because when you asked it, I thought, is there a application for a temporary use?
I was more on the same frame of mind that you were, because my thought was temporary leases are firefighting, road construction, those kind of uses
Yeah,
where it's seasonal type thing, and you typically lease an existing water right from a existing water right holder or something like that.
temporary use doesn't always have to be a lease though either, does it?
No,
Temporary use
no.
can be an emergency
Yeah, yeah.
uses, right?
right.
Just firefighting and that. kind of
Yeah,
stuff.
there's,
So,
there's
so if
multiple.
there is a temporary. So the question is there a temporary use application?
We don't have anything like that, at present, Mr. Chairman.
Mr. Chairman,
Yes,
specifically, the section is only for leases and only for road construction or dust abatement.
the 22122.
Yeah.
5. Okay,
Yeah, Mr. Chair, I was also going to clarify that there is a specific type for like mitigation of in emergency situations under the ordinance, and it's termed differently than just temporary use.
so do we need to cover that somewhere too?
That
Or
is
does
an
this go-
entirely separate process from this.
Okay,
You know, to clarify this, maybe instead of saying temporary use, we say what the statute says, and that's short-term use.
did you hear that, Haley?
The statute uses both interchangeably, but yeah, I mean, we can stick with one and use whatever's gonna be more clear to follow.
So my follow-up question is, if the formal complaint is the process that would be used for temporary use, is that a fast enough process to address a temporary use, since temporary uses might come and go faster than the hearings process?
Short-term use is only for 90 days.
Or not? So maybe the hearings process is fast enough for that? I don't know. Yeah, I don't, that's my question.
Mr. Chairman, board members, we would, within 3 days of receiving a formal complaint, serve via mail, the notice of the complaint, which would start the complaint hearing process.
Okay.
And so, as fast as we can get. Now, of course, if the short-term use is shorter than 3 days, it's probably not gonna,
Yeah,
get there, but
just a question, yeah.
it is a frighteningly fast turnaround on, what happens when a formal complaint is filed at this office. So I'm not, just to make everybody very aware.
That's fine, thank you.
I guess just to refresh my memory though, do we have a form now, an application form for short-term lease use?
We don't have a formal.
Okay. So then we're a little ahead of the curve with this, without having a form.
Yes.
Okay.
We tried to make a complete package, even though some of the items may not be at full measure, but this was, the effort was to try to make a complete set of complaint procedures. And some of those, the ones that we were compelled for that specific ordinance reference to include that, because it is so specifically called out in the ordinance to the way to file a complaint about temporary use or short-term use I'm hearing the board prefers. Is that? Did I get that correct? The board seems to generally be
Well,
trending towards.
That was Ken's comment.
Yeah.
Do you prefer that, Ken?
I do.
Okay, and
George, you good to that? Roger,
Yeah,
Georgia?
I'm good with it. I'm just looking at the. Now, in the actual verbiage here, and it refers to temporary way more than short term. That word's used a lot more, so I don't know if that makes a difference.
Ken?
You're looking at 122?
And 2-2-120. Exactly, let's read through that section. Yeah, so you're right, in 121, it switches to short term. And then in 122, it's short term. But it's used multiple times as temporary. In the prior section, so. I have no idea what that means legally. I'm just counting words. That's all I got. I don't know if that makes a difference.
Short term the title and temporary is the verb.
Back to those verbs.
Well,
You know, it's,
I go with your judgment.
well, no, it's not my judgment. I'm just saying the title says short term, so.
yeah, your preference, whatever listening to Haley, she said either one works, so whatever your preference. is.
Whatever you say.
Mr. Chair,
Dan, what
may I
do
make a suggestion?
Yes,
If we are going to be switching to short term, I would suggest that when it's first used, you do have some sort of parenthetical of temporary use, because under 22122 sub 5, it does specifically state complaints regarding temporary use. So if somebody were to be looking at the ordinance, just for clarity purposes, as long as it tracks within the procedures and it's, parenthetically designated as short term, I would feel comfortable with that messaging.
we do
Yeah.
flash that also. That's done. Okay.
you wanna do it that way? Sure. Okay, so let's read that. Let's see what it says.
Mr. Frakes, you feel comfortable doing a real-time edit on this document? It's just a word version. Excellent. Sub 3. I believe that the going deal is to write in front of temporary, the word capital, no, at the title, yep, capital short hyphen term, yep,
And then
and then parenthetic temporary afterwards. Is that what? That's what I believe I heard.
that's what I heard. Okay,
And that would need to also be broadcast on page 3. Item 2. Resolution of, if you could do the same arrangement in that title. Right.
So I guess if you're making those edits, you might as well go down to number 4 and change your form 610F there to 609F.
Same on number 2. Yeah.
Yeah.
Haley, Ethan, question, I don't know why I'm thinking about this now, but you can file a complaint if you have a water right or reside within the reservation boundary. Thinking about upstream, downstream issues. What if somebody downstream of the reservation has an issue with water use coming from on the reservation?
So the formal complaint has a really specific burden on who can bring a complaint. So it's essentially any appropriator who's aggrieved by an action or inaction of another appropriator, and so it doesn't actually distinguish between boundary. But it does specifically state that it has to be to an issue of wasting water or illegal use of water.
So if somebody feels impacted by someone's use of water, that doesn't count.
At least under the circumstance for a formal complaint, and that's exactly why there was a reason why the informal complaint process was requested as well. However, there is a limit with that where it does need to be within the exterior boundaries of the reservation for the informal complaint.
So I hear you. I'm just a question then, if somebody off reservation has an issue with a water use from on the reservation, how would they go about dealing with that if it doesn't fit within our complaint procedures?
I mean, I guess depending on what their action would be, they would have to find some sort of recourse within the state procedures.
Is this one of those court of competent jurisdiction issues?
It would not necessarily be something that the office of the board should be concerned with in terms of that, or it's not their burden to determine that. But no, I don't think in that sense.
Okay, well, I'm don't know why, but it's on I'm thinking about that, so you might keep it in mind. Future discussions, I suspect, when we are faced with it.
Mr. Chairman, board members, I would like to just coordinate with the respective regional office manager for the off reservation portion, see if we can resolve things
Find a way to resolve that.
that way.
Okay, that was just a. Hopefully never run into it. We are an island. In this. Western Montana.
Matter and everything.
Yeah. Well, yeah, okay. More questions, comments? So is there enough, are there enough changes to this that we need to bring it back, or what are you thinking about? These complaint procedures today?
Mr. Chairman, board members, I do not think that there are enough changes between the form number and the title change. That anything needs to be brought back. That said, the board really has to decide if what they want to do with this product. So it's just the opinion of the engineer in terms of the quality of the procedures. Doesn't necessarily mean that you have to take action.
Board members? More questions for Ethan or Haley? So if we're prepared to take action here, Haley, since it's already been out to public comment, do I take public comment again? I think I do for action.
Yeah, you would take public comment on your action, yep.
Yep. Board members, are you ready for public comment? Yes, put it that way.
Yes.
Yeah, I don't think those changes are substantive, so.
Okay, any public comment? And the crowd says no.
We lost-
Anybody online?
If anyone online wants to make a public comment, you can
Attendees.
raise your hand and we'll allow you to speak. Seeing no public comment online.
All right, these having been out to public comment, been reviewed by technical staff, legal staff, and with a few minor changes today. The board is ready, we'll take a motion to approve.
I'll make a motion to approve the Office of the Water Engineer's complaint procedure with the typographical changes we made today.
Motion by Ken,
I'll second it.
second by George. All in favor, say aye.
Aye.
Aye. Any opposed? Hearing none, it is approved with those changes. Thanks, guys. Step by step. How do you eat an elephant? One bite at a time. Yep, a lot of bites.
How many total meetings has the board had?
It's a bunch. I'll give you a count at the next meeting if you want. The last time I counted, it was pretty impressive.
That's how many bites. So Ethan, with just a question, with the actions we took today, are we able to help the gentleman with the cattle? The 9 cattle?
Mr. Chairman, board member Spees, we can now offer the folks in that area an opportunity to file a complaint with our office. At which point, that may, we look through the complaint for the validity of that, and then probably do some additional investigation and all towards trying to seek a remedy. That said, I don't know what that remedy is until I go out there and take a look at things. If they fall through with, taking the opportunity and use this vehicle.
Good answer.
The board has provided.
Thanks. Ever since you shared, all I could think about was thirsty cows, so.
Okay, so now are we on number 5?
Sir, yes, sir.
All right.
All right, Mr. Briggs. Think it's, we'll jump right into the 5.1.1, if that's all right, Mr. Chairman.
Go for it.
The Flathead System compact water. As the board recalls, we've got a little bit of pressing need for options on how the Office of the Engineer will address Flathead System compact water use. As a result, what we've done here is we try to draft some language that is intended to be helpful towards offering some additional clarifications that the ordinance is a little vague on. In this kind of detail would help to fulfill the the board's policy on how we're going to look at these types of uses. As you'll recall, we have had a briefing on the Flathead System compact water right itself. It's a quite large water right. That water right is already a part of the compact. Therefore, that water use, in our opinion, does not need to undergo any kind of a physical or legal availability test that would normally be applied to a new appropriation. So this is it does.
Can we hit pause right there?
Yes, sir.
And I heard you say that before, and this is for you and Haley. And I get that, I understand that comment. Except to the extent that we make, if we get to the point where we've reached the limit of that volume. Would that be correct? I mean, we must have to monitor what that volume is that we're approving against the supply. So I think early on, that's probably 100% accurate, but if we ever get to the point where what we're approving approaches the limit of the supply, then I think that's not quite accurate.
Mr. Chairman, good clarification. And as we step into the initial phases of this, I think it's around 128,000 acre feet of consumed use. We do note that there is a clear need to solicit information about the diverted volumes on a month by month time step and consumed volumes on a month by month time step. And that information needs to be collected in a way that can be additive for any of the uses of this water right off of the reservation. As the board may remember, this water can be used on or off of the reservation. And so we do have plans to have coordination of those volumes both on and off the reservation. And so collection of the information about the use that includes that out of our office, and then becomes additive with any uses that may occur off the reservation, all for the purpose of making sure that we do not there's not an over allocation in excess of the water rights diverted or consumed, elements that are a part of it.
Thank you.
And that does bring you right to item, sub 1A, B, and C. We think that those are just essential things that need to be provided, in the application. So, the ordinance does not specifically call that out, however, the language in the abstract of the water right compact does signify that information needs to be collected both on and off the reservation, and so we've added it here as an expectation for a successful application.
Yeah, and that's true, but then we go on to say an applicant is not required to provide information demonstrating physical and legal availability. So is that, so I'm questioning, is that true?
Mr. Chairman, board members, we do assume that if this water is sourced out of the main stem, first of all, physical and legal availability are terms of art that are specific to water right application, in that typically an applicant who wants to use some new water that has not been used before, they would have to come in and they would have to provide credible information that A, the water is physically available at where their proposed diversion is going to be, and then oftentimes the harder one, B, that water is legally available. In other words, not already legally spoken for downstream, because it's not the first in access does not have priority necessarily. So those terms of physical and legal availability in this case are very specific to that kind of a look at a new use of water. However, flathead system compact water uses are predicated on a water right that has already been determined to be physically and legally available within these fairly complicated conditional set of flow requirements and reservoir ramping and other types of requirements that are specified, but that water through a combined level of modeling and determination by the compact and the negotiations that went into the compact has already really been asserted. So the water right exists. We in our office can move forward recognizing that water right does in fact already exist. Therefore, what we would be authorizing is use of an existing water right. And we can assume that existing water right is just that. The water is there and legal, and we can go on the next decision-making phase, skip right over that. We will not be able to skip right over that phase for new appropriations, i.e. permits. When somebody wants to come in and get a new surface water right, they will have to jump through a lot of hoops to show that water is physically and legally available.
So Ethan, thank you. I'll get, so Haley, I'm just trying to pose that same basic question to you. So given that explanation, what happens when we reach the limit of the supply? What responsibility does the board have, or is that up to someone else to determine there is still water available?
Yeah, I mean, so Ethan, did any of the board members receive this abstract for this particular water right?
We distributed it during an earlier meeting and went over it during that meeting, but we don't have it in front of you right now. However, we can pull it up in front of you if needed.
Yeah, I just was curious if anybody had it in front of them. There are particular requirements within a remark on the abstract of this water right that pertains to monitoring of depletion levels, of just volumes in general, for this water right. And so, the truth is, I don't know what the answer is when it gets towards a depletion level. There's not really any procedure on whose call it would be. The thing I can tell you is that there's a lot of entities involved in this water right. And there's a lot of resources that, the office and the board do have to consider, as part of the remarks that were left on this water right.
Well, so is that statement that we're looking at, is that the best statement to have in there? Is that adequate? Is it accurate?
So I'm gonna be honest, I can't see the screen that you guys are working off of. So I don't know where you're at right now.
Let's get that language in front of,
Thank you.
so that's, yeah. So burden of proof. An applicant is not required to provide information demonstrating physical and legal availability of the flathead system compact water source.
Yes, I mean, that's a, very true and accurate statement, at least within the confines of the ordinance. Specifically under this procedure, the office is, subjected to evaluate the criteria under 22102, B through F, which does not require physical and legal availability. Because the flat system compact water, any new developments of it would be a change, not a new water right.
So. Okay, let me put it this way. So now and forever, any application for this water comes through, we just approve it.
Not necessarily.
Okay, so what's that limit and why would this sentence still apply?
I think I see what you're getting at, and, like maybe an option, Mr. Chairman, if I'm reading this right. He said if we were to maybe add in a sub D here and, say something to the effect that, if any of the amounts in A, B, or C are found to, A, B, or A, yeah, are in excess of the cumulative prior issuances of the total water right value.
Why do you? Is that German?
The application maybe, or something to that effect. Is that,
Well,
I'm just thinking off my feet.
And I
here,
think,
Chairman.
and I think that language makes sense.
Uh-huh.
I just still, and if Haley, you're comfortable with that and keeping in 2A, I'm fine, but that's, I mean. You mean, if you're not able to answer the question, what happens if we reach the limit, we gotta put something like this in. Just makes more sense to me, but maybe I'm way off base. I wanna go back to some comments here. I know Ken had his hand up earlier.
No,
You good?
Yeah.
Roger?
I guess I did have. a
Oh, yeah,
question for
yeah.
Haley. Haley, I didn't hear that citation you gave.
Oh, for the criteria that the office needs to evaluate,
Yeah,
it's 22102, and then it's, 2B through F, sub 2B through F.
thank you.
Mm-hmm.
All right, Roger, did you have?
Well, in general, I think once you hit that appropriation, you're gonna close the basin. That's what's gonna happen.
Yeah, well, who decides it? But if we receive an application and they're not required to show legal proof of availability.
Well, but I
Then
think
we-
that goes back to speak to what Ethan said earlier, is that he's got a running
Yeah,
record
those-
of how much there, and once you hit that limit, then you're done.
Georgia,
Well, I was looking at the compact, and in section 2-2-118. We're not the first people this would come to, if I'm reading this correctly. It says that, subject to the terms and conditions of the compact, the tribal council or its delegate, or any person with the written consent of the tribal council or its delegate may apply. So what, does that mean it goes to them first before it would come to us? Like, they have to get permission, if I'm reading that correctly, it sounds to me like they have to go through tribal council before they make application to the board, or did I not read that right?
Haley?
You know, we had one, I mean, I think we talked about this briefly, when we first introduced this. I'm not exactly sure what the parameters are of what the tribal council will do, but, the reading of the language that Georgia is pointing out, to me only signifies that the council just needs to approve that the tribe or the delegate will make or submit an application, that's all. There is no analysis authority, at least to the level of what's intended in the ordinance, upon the tribal council.
Thank you.
So it's maybe just me, but then given the language we have up here now, we're looking at. In my mind, there's a conflict between A, B, C, and D, and then 2A. I just, if you're good with that and we're able to manage that for ourselves with that language, fine.
It
Yeah.
kind of means, sorry, go ahead.
No, I mean, I was just gonna reiterate that physical and legal availability are two very different things, than just volume. In terms of a legal evaluation, or at least an evaluation from an administrative level. So yes, I see those as completely separate things that the Office of the Engineer is not required to evaluate.
Well, we can keep it in, we can add the language we just added, we can do it. I just go on record, I'm uncomfortable with it, so it's just me. So anyway. Anyone else?
Can you scroll down more?
Mr. Chairman, board members, I'll keep talking here unless you tell me, not to. So we sub A is what we don't think we need in terms of the burden of proof, and it's specifically called out there because we require that. So B is that we still do want to see, that there's going to be an adequate means of conversion. For us, that really means, is pipe size capable of moving whatever your proposed use is? Does it, just that is it accurate, and then ditch sizing, pipe sizing, pump sizing. We don't really want to have an issuance for something that is twice as big as what could be conveyed, or something to that effect. So that probably seems pretty straightforward. That's we're gonna see that in a lot of water rights, and this is a good precursor to other looks at changes and new appropriations. Sub C, here, this is the spot where we want to make certain that there is no depletion from other sources between the source of supply and the place of use. And so right here, we're comfortable, this is out of the direct source of supply on the Flathead Main Stem and the Flathead Lake. However, you know, we want to make sure that as the water is conveyed from point A to point B, that there's not some indirect adverse effect to somebody else's supply. Instances where it's a pipe, that's solid pipe, that goes, it's pretty easy, right? You don't see a whole lot of interaction. Instances where maybe they're gonna co-mingle flathead system compact water with other water rights in a ditch that's already in existence, that might be a little more complicated, but we're gonna wanna make sure that the new use wouldn't usurp some other ditch rights that have access to that ditch by modifying the total ditch capacity in a way that limits folks. So hopefully that makes sense what we've got there. And then in sub D, what we've got going on there is there are a lot of requirements of minimum in-stream flows in Flathead, ramping rates.
What is that?
Ramping rate is how fast you are filling or spilling a reservoir. And there are special conditions for like Hungry Horse Reservoir in that the ramping rates are not supposed to be so rapid that it creates a Vados zone, which is a large area where, see, when it's a little, kind of get into biology for a second on why the ramping rates are important around like Hungry Horse Reservoir, because in a situation where water goes up and recedes, it resets the biology for that surface to ground interface. And so the biologists are pretty particular on what those ramping rates are on Hungry Horse, and also what the spill rates are, because you can reset the river biology pretty easily if you have a big spill and then you drop it down low. That means that whole area that got wet and then dry is going to have a harder time recovering for water emergence and some vegetation. But
Is that
this,
Good. I just want to know what a ramping rate was.
and yeah, and so these things are very specifically already called out in the water right abstract. You know, along with the additional technical reports that relate to that water right. And we're just saying that you gotta have a plan for complying with that. A plan that would work for us might look like, okay, if we are gonna monitor these flow conditions in the main stem of the Flathead, and if they drop below such and such, right? That would work.
Doesn't, Mr. Chairman, it seemed to me like the way it's written, C kind of contradicts A. I know what his intent here is.
Yeah, I think I kind of see C as a little different. Impact from whatever use it is, it's a potential impact. A is whether or not the water is physically or legally available to put to that use. C is whether or not that use impacts somebody else.
Which is part of it.
I don't think so.
No, it's
I
not.
don't think so.
Uh,
I don't think so. It's the A is on the front end, C is on the tail end.
Sure.
Yeah.
But I still think they're linked,
No,
because to prove legal availability, you have to show you will not adversely affect other water.
no, adverse effect has more to do with whether or not the use the water you're putting to use is not actually depleting someone else's. Now, to the extent that we get to the limit, then I think you're right, but that's my question. That's still my question is, if we get to the limit of that supply, whose responsibility is it to determine that there is legal and physical availability? If it's not ours, it's somebody's.
Isn't that what is trying to be determined in the Colorado right now? Same kind of question, right? Who has the right to the water in that basin? And everybody's arguing over it. So that's a really good question to get answered on the front end of this thing.
I think we've got some time to wrestle with that because there's so much volume, but I think we gotta think about that.
Well, they thought that in Colorado too.
Yeah,
We thought we'd never get to the. end
Yeah,
of it,
yeah.
Right?
For what it's worth, do be aware that the Bureau of Reclamation modeling was intentionally designed to address the main stem consent decrees for salmon releases and all the other downstream ESA obligations
On this one.
on this water right in
Yeah.
particular. So it
It's
has,
not
it has a ton of work also designed to accommodate the Montana Florida flows. It's clear.
That's encouraging. to
You
hear.
know, yes, just for what that. A lot of thinking we're gonna do it.
Sure.
The amounts.
Did they model
But I
for
do-
climate change impacts?
What's that?
Did they model for climate change impacts as well, and they came up with that number?
You know, not all.
That changes everything.
But I do think that the chairman at least prompted a good addition on sub D, even though I since he's not totally sold that takes care of his 2A issue. I think it was an improvement.
well, given all of that discussion, my personal request is that Ethan and Haley continue to consider that. Because I think and I think Haley, you even said you're not sure who would answer that. Well, it'd be nice if I think maybe more than nice if we figured out who is responsible. So anyway, if not today, sometime.
I think the reason why I say that is because there's a lot of entities that the office and the board need to work with when assessing this water right. And so I think it would have to be a collaborative discussion on that and not necessarily be a board decision with that.
Okay, we're getting there. Thank you. Off base.
So, James, Mr. Chairman, James made a correction.
Yeah,
that satisfies my concern about.
Okay,
With that, and then basically what used to be sub C in its place.
just moved it.
Yeah, so it's all in the same.
On item D, Georgia mentioned this a little bit. This is again under the burden of proof, but there is a requirement that the applicant must provide a plan to adhere to the minimum, or excuse me, the applicant must provide proof of written consent of the tribal council or its delegate to use a portion of the flathead system compact water. And that is pretty straightforward out of the ordinance. The highlighted provision, however, is something that I have encouraged us to consider. Haley has, it's highlighted because Haley has some discussion topic on this also, but our thinking is that applications filed directly by the tribes, the Department of Engineering and Water Resources, DOR, are assumed to be in compliance with this provision.
You know, and maybe, just maybe, D is the nexus that answers the question about physical and legal availability, because if the tribe, as Georgia said, if you look at this and if the tribe has to approve, if this is a compact issue, then this is going to be the nexus between the tribe and the state in that case. And someone's gonna be keeping track of how much water is being used and whether or not they've reached that limit.
We do have a tracking spreadsheet that we've been working on that's meant to.
Whether we do or don't, somebody else is gonna be
Yes.
between the state and the tribe, I imagine.
I have a question. Who would be
Like,
applying for this water?
we got an application coming soon, don't we?
It's not coming. It's on my desk.
Who applied?
There is a specific applicant, but the application was given to us by the doers program. So,
It can, well, there is an applicant, so
yeah.
is it somebody we can announce now or no?
Or perhaps categories, would be helpful for me. Can only state and tribal entities apply for this water, or can private individuals?
Okay, so it's a little bit of an interesting answer. Off of the reservation, there is 11,000 acre feet of water that the state can dole out for mitigation of domestic, commercial, industrial, and municipal uses. Any other types of uses used off of the reservation, which could also include those same purposes, would have to be approved by the tribal council. Okay, there is a money component also on how much it costs to use the water, and that is complicated. I don't really want to get into the economics of how that works, but I do want you to know that there is an expectation that the water costs something. You know, how the tribes would decide to use the water for, you know, purposes that are not associated with that state allotted 11,000 acre feet really seems to be much more up to the tribes. And so I wouldn't speak to that. Similarly on the reservation, the 11,000 acre feet does not apply. And so any uses of water on the reservation have to be approved by either the tribal council or its delegate. And those purposes, you'll look at the purpose on this water right here, and it's the only water right in all of Montana that has this purpose. You see it's down there below the enforceable priority date. And it says any purpose. And so that is a uniqueness to this particular water right type, in that if you meet the terms of the diversion, what we're trying to lay out as the final requirements for an application for use of the water, then that use can be any purpose. Furthermore, there are provisions for short-term leases of this water to the irrigation project, which could be diverted either through the pumping plant in Folsom, or there are a couple of other ways that that's water could get into the system, like the Crow pumping plant potentially, or new infrastructure that may or may not be built would have the potential for this water to go into the irrigation project. Some of those arrangements are more hardwired than others in terms of what is part of the shared shortages provision versus whether or not folks might be able to come in, enter into agreements with the tribes to use that water, or whether which includes tribal members. So there could be an array of different types of arrangements, I'm just going to say, that would go from leasing to however the tribe decide they want to share that water with their own membership. I don't know.
So I just want to make sure I heard you. So here's what I heard.
Okay.
That the compact negotiated water right for the tribes can come onto the reservation and be made available to tribal entities and private parties who may or may not be tribal members.
At the discretion of the water right owner. Yes.
Okay.
Yep.
I think that's important for people to understand. And I don't think it is well understood.
Probably not.
That you're a dryland farmer down in Charlo and this could benefit you. Hypothetically. I don't want to speak for tribal council, clearly, but that is something that could happen. And I don't think people get that.
It's an opportunity,
Mm-hmm,
is there?
mm-hmm.
There is a condition that this water has to be used in Montana. I'm gonna mention that because that
It's
is.
not going to California by
Not-
truckload at night
That is
with black helicopter.
correct. The uses of this water right have got a very strict in Montana arrangement.
That's good to
So-
point out too.
Yep.
Okay,
One thing that might be helpful is if you, and I don't know, Seth wasn't probably involved with writing this stuff up, but if you could put a whole presentation together on that for the board so that we better understand how it was generated, why it was generated, it would really give us a better understanding of it, of the basics of it.
And how they being the tribe and or any other party plan to manage it.
Yeah,
well, they could
I mean,
take
it's a complicated thing.
Yeah,
well, it's gonna get
yeah,
more
let's
complicated.
let's do that.
I'll be happy to do something to that effect if and I'll certainly reach out to Seth or somebody else, see if they'd like to share additional information on how they might be looking at this.
And the reason I mentioned
Or-
Seth is because I can kind of remember going to some of those compact meetings and they had a PowerPoint presentation and it made so that some of that may already exist.
I'm pretty sure I have it on my computer.
Yeah.
And so I'm happy to do that to the board, at least share the presentation, if not share it here in this meeting.
I've totally forgotten about it. So,
Yeah, that'd be good, Seth, you know, I think. Maybe a combination technical and legal presentation, because
Great idea.
I think Melissa would probably contribute quite a bit to that, but so, yeah, think about that, and if you can get that, that'd be great,
Sure, sure.
good idea. Well, you're highlighting there and your question, so is that a good assumption? Assumed to be in compliance with this provision.
Haley, I don't know, did we get to giving you a chance to say what you had to say about this section?
No, I mean, I just, I don't know about just the assumption piece of it. Because the office is specifically required to, assess whether it's a correct and complete application regardless of, who the delegate might be from the tribal council. So that's just my concern.
I thought was valid enough to highlight so that you would hear it here. Okay.
So grammar wise, I would rather say presumed,
Okay.
and I would say presumed to comply with this provision.
Well, let me back up a second. So Haley, I hear your comment. So what would you recommend if not this?
Just in case she forgot, she did recommend to me previously that it just gets deleted.
Yeah, I mean, that would be my suggestion.
And I presume that's what you meant.
I was coming at it from a different angle, but presume is a legal standard.
No, I get, but I mean, I reading between all the lines, I thought maybe that's what Haley was getting at. So the question then would be keep or delete that piece in yellow under D. Yeah, but you'd have to convince me we need to keep it.
Yeah. It's kind of a presumptive statement.
Well, I think that's why Ken said what he
Yeah,
said, but I think, could we live without it?
Yeah, I mean, for us, it's more of a courtesy and make things easier for the tribal council if they would just delegate that to the to doers. We can also just rely on them providing us some other kind of MOU that's set aside. Standalone. Everything.
Well, I'm comfortable with them having to comply with with the process. Such that I don't think we need that.
All right. Sure.
That's me. So, anybody else?
Just send notice out that, to everybody else out there that Department of Engineering and Water Resources aren't gonna be meeting tribal council concerns. Sort of more the notice function than the functional function.
Well, then we should just say that, but that's not what this says.
I concur.
We can leave it out. If they tell us to put it back in during the public comment phase, you can reconsider that. That's how I recommend you move, and you should just jump right into this water quality section now, because we got an hour. And
That's for the comment right there.
and I
Gone.
yeah, and so Mr. Chairman, board members, what we have is there are some hardwired requirements in the ordinance regarding certain water quality provisions that we need to address in a water right application. And in this case, there's 3 of them. The first one is that, our office is supposed to determine whether or not, there is a water quality degradation to other water users. And the next one is whether or not a proposed, water use, this goes for flathead system compact water use, this goes for permits, this would go for changes. And so this is something we have to figure out for those other essential items on our priority list. Then we also need to make sure that things, meet the water quality standards for, the tribe's water quality program. And, so if you scroll down a little bit. So sub 2 is the next bit where we talk about the Clean Up Water Act. Is the second one, and then the third one here is the tribe's ordinance 89B. Okay, and so thank you. We'll go back up to the top one here, which we have less reference to another regulatory entity for a requirement to determine whether or not water quality is going to be adversely affected for another appropriator. So what we have here is we have these 3 items we think we would need to require an applicant to provide information describing all possible water quality degradation. The applicant would have to provide information describing the geographic extent where potential degradation may occur, and then a clarification that, we will not evaluate water quality considerations beyond the direct effects of the proposed water use and application of water, and will not consider water quality degradation issues regulated by another agency or governing body. For instance, if there's an application for irrigation water, okay? Sometimes irrigators use fertilizer and pesticides.
Well, they all do.
Right, so that is not part of our consideration in this section. Our consideration would really just be the water itself. We would leave the pesticide and the fertilizer management to the other regulatory entities that are more directly charged with managing water quality. So, see what I'm saying? There is a direct implication of the uses of those, but we do not solicit information about pesticide use or fertilizer use in our typical determination of whether or not a water right will be issued or not issued. Okay.
Go ahead, I have thoughts.
Yes, well, I totally tried to cue you up to have thoughts so that you have, this is the description of what you're seeing. So you can, accurately modify that as needed. The sections after this, where we recognize that there's not supposed to be any violations of the Clean Water Act, 33 USC section 1251 and then also the tribes. What we rely on here is that we need to see a plan that they're gonna be able to adhere to that, and if we so choose, we can request that the applicant obtain a written verification
Where are they gonna get that?
from the entity that manages.
Where is that? Where is
On the
that?
reservation, the tribe's water quality program manager, Evan Smith, would be the contact.
So he's on board with giving out these verifications.
We have not approached that. This is an approach that we're throwing out there right now as an option that
I think before we get to that, we need to unpack the steps that come before it.
Yep, let's go back and so hit pause, yeah. Yep, right there. Go ahead, Georgia, you start.
Well, I have a lot to say. So I'll pause and as we go, and you guys interrupt or tell me to blow up.
Well, I wanna jump in and ask this question. I'm gonna have to go back and look at the ordinance if I wanna be clear about what sections of the water rights ordinance really have water quality built into it. Haley, Ethan, can you help out there? And the reason I ask is because you look at the language of that ABC 1, 2, 3, whatever that was. Holy cow. The language here says any possible, any potential. How do we determine? I mean, that's so broad. Somebody could apply and we say, well, you haven't listed all possible.
Well,
You
not,
haven't listed all potential.
not only that, then they're gonna file an objection and say they didn't do this, there's this and this and this.
Or
You-
someone else is gonna say they didn't list all potential or all possible.
You won't,
You missed one.
yeah, and it'll come to a hearing and you won't issue a water rate.
So going back to what our ordinance says about water quality, how does that language comport with what we just read?
So, I guess one thing, if we could go back to the other screen that we were on. I guess one thing that might be important to talk about is if you look at the language of the water compact, it's referring to this water right being water that is held in Hungry Horse Reservoir, the Flathead River, or Flathead Lake. Under the language of the water quality standards that the tribes have, which supersede the feds, and that's important to know. The tribes are a sovereign government and their standards supersede the restrictions of the Clean Water Act. And the tribal water quality standards are much more strict and much more restrictive than the federal Clean Water Act. And I can talk to you some about beneficial uses, which I think is important at this time to talk about in this section, because a key component of water quality standards are beneficial uses. The tribe's water quality standards are unique in that they include traditional and ceremonial uses and sacred uses, per verbiage provided by Dr. Michelle Bryan out of University of Montana. So those sacred uses are a huge umbrella that are super, super protective of water quality. So Flathead Lake is an A1 water body, which means it receives the most restrictive or most protective water quality of all water on the reservation, except for A closed, which would be for drinking water supplies and the Crow and Hell Roaring. If I'm reading this correctly, an applicant would be asking to take water from the lake or from the river to use somewhere else, right? Meaning they're getting really good water. So the question is not, are they getting water that's meeting water quality standards? We pretty much guarantee that they are. And it sounds to me, if I'm tracking the conversation, the applicant is not having to demonstrate how they're going to use that water or affect its water quality. What's required here is that the water they're getting is not going to have poor water quality. Am I reading that correctly?
It must demonstrate that the proposed use will not adversely affect the water quality of another appropriated, I'm an applicant. I cannot affect the water quality of another appropriate. I can't affect your water quality.
Okay, so I wasn't reading that correctly.
So given that, as an applicant, I have to provide information describing all possible water quality degradation that may occur from my use. How do I do that?
There's no method for that right now. I
How,
can,
how do I do that?
so the EPA has a defined anti-degradation policy within the water quality standards, and it's a bear. It's not easy to meet. And it's usually put in place for things like mixing zones below wastewater treatment plants, something like that, and you have a use attainability analysis. I have never seen that applied to a private individual. Like it could be in this case for an applicant.
Yeah, so Haley, given that, looking at E sub I sub 1, just that far, how does that language comport with the requirements of our ordinance?
I'm gonna have James pull up the ordinance real quick. Got a section there, if you should be able to find it. Yep. So D, E, and F are things that we think we need to specifically address in terms of the water quality issue.
Now, orient me, are we still just only talking about the flooded compact water?
No, this will be,
But this was just compact water.
That's why I asked, because that's what I heard.
Gotcha, I didn't get that.
so we're gonna have to address this for all those permits and changes and everything. We'd like to use the same approach.
I'm seeing this. But I'm just wondering if there isn't a more narrow way of phrasing it in the other document, because to say all possible, I don't know how to do that, but to comply with this, maybe it's more basic than that by saying, reaching out to the water quality folks and saying, you know, and it's the applicant's responsibility to say, look, this is what I'm doing. I'm reaching here, but this is what I'm doing. Can we somehow document that I'm not going to affect somebody else's water quality? Can they provide that?
So this won't answer your question directly. But the other, okay, so we have a problem for the applicant trying to satisfy this language. But this also poses a huge problem for the tribe's water quality program. Right, because the tribe's water quality program is funded under section 106 of the Clean Water Act. It's a limited budget. It only supports, the last time I checked in with Evan, I think they've got 10 core monitoring sites. George, you probably know better than I do because you provide the flow measurements. So you got about 10 core monitoring sites, and there's some leeway in that. And those have been evaluated every month between usually March, April to October since 1992. Some a little bit longer than me. So they have 30 years, 30 plus years of data on 10 sites. to add additional monitoring is incredibly expensive. And to come up with requirements, like how do you satisfy that? How many monitoring points do you need? For how many months? You can't do a single point assessment. It can't be a one-off, a one and done kind of thing. There is a 30-year database that pretty well characterizes general water quality in each of the major watersheds. But not enough, with enough resolution to answer these questions. And so the tribes can't afford, I don't want to speak too much for Evan. Evan, if you're listening in the future, which I've recommended you listen into this. You know, that's an incredibly expensive thing to ask the tribes to do too.
And I can add to that a little bit in that they added a pesticide study that's been going on for about 5 years. We go out in 1st of June and 1st of August and sample for pesticides. On about 10 sites. That a lot of them are below sewers and that type of stuff.
So what is a most of the applications that would have to comply with this? The most basic, most common one would be what? A new appropriation. Okay,
Yeah.
so a new appropriation. Define them.
Somebody wants to put in, new diversion to irrigate, 20 acres, Yorkshire, something like that.
Okay. How is that applicant going to prove this? How are we gonna do that?
Well, the applicant could say, I'm gonna use this water with the sprinkler and application. It's gonna stay right where the sprinkler pattern is, and therefore there'll be no interaction with other appropriators' water as relating to my use of water. That would be the easy way to explain it. I intend to apply water in a way that most of my water, the vast majority of my water will stay on site and be used to either wet the soil or consumed through ET. Harder one would be, I'm looking to flood irrigate. And in flood irrigation, you have excess water that can carry soil and other contaminants towards other appropriators. In that situation, the irrigator would have to provide a plan that demonstrates that they'll either use a border dike system that keeps the vast majority of their water on site, or water that was going to leave that site would probably do so through a seepage / filtration array.
And therein is going to lie another problem, because there is a huge difference between point source and non-point source water quality issues.
Well, I'll throw you a curve on this.
Oh, yeah.
Yeah, this is from an actual case study that was done up on East Shore. So let's use Jane's example. You want to take A1 water, quality water out of Flathead Lake to irrigate 20 acres of cherries at Finley Point, right? Okay. Tim Sheedy wants to put in 500 acres of cherries, right? I don't know, just making up an example. But let's say that's something somebody wants to irrigate. They take water out, they irrigate, and to use George's good example, they're also having to apply all kinds of pesticides on those cherry trees in order to be able to sell them anywhere. Walmart won't carry them if they don't have gobs of pesticides.
Gobs.
Gobs.
Requirement in the
Quantitative number. Okay, so Yellow Bay Biological Station did a long-term analysis of water and water quality on cherry orchards on the east shore. And what they found is that, those pesticides, when applied to those irrigated trees, the pesticides become airborne such that the water quality up gradient upstream of the point of diversion and irrigation was actually worse than what was downstream. So that water is getting, another appropriator's water is getting adversely affected.
Yeah, there is a reason why the EPA promulgated its regulations for the Clean Water Act. They focus on what we're putting into the water, not what we're taking out. And in my opinion, this is an unreachable goal. And the only thing I think you can do is what EPA is trying to do in some states is use the best available science. And even that's not going to get you past the first hurdle, because you're never going to please everybody.
So let's be clear, the language that you put in there in the procedures, I mean, that's fine. This is not about challenging you or anything that you're trying to accomplish. It is about us trying to understand what this says
Right.
and how do we do it.
How do we do it?
And Haley, let me hit pause here. Any additional thoughts to help clarify this for the board at this moment?
Yeah, sorry, I have like
There's my
5.
answer.
No, I have like 5 things that I've wanted to, I mean, I've tried to interject maybe, but wanted to let you all get some thoughts out too.
Go ahead.
So one with, let's just take D for right now, and we can just look at what's on the screen. So the intention of that was to mirror the requirements that DNRC has in terms of evaluating water quality. What they do is completely separate from what DEQ does, where they look at non-degradation standards. Like DEQ looks at that, not DNRC. And so in issuing a water right, the water quality essentially comes up in legal demand context, not necessarily non-point sources or non-deg standards. So that was the intent with D from the legislative perspective. And then I believe E and F are like worthy attempts to bring in the entities that are responsible for water quality standards, i.e. non-deg standards. And so having to require the applicant to go to the tribe's water quality management bureau or department, I apologize if I don't know the correct name, to actually have their approval, that it will not, conflict with, one, the classification of water set out for the source of supply, and 2, the ability of a discharge permit holder to satisfy effluent limitations. So D is like wholly water rights evaluation of water quality, whereas E and F are more intended for that non-deg kind of look at it.
So given that, should there be a way to, and I'll just say simplify, it's not a simple subject, simplify or write more direct language for the procedures?
Yeah, I mean, I don't like, whatever that A is or 1 or whatever it is. The applicant must provide information describing all possible water quality degradation. I don't necessarily think that's any different than what I is, like sub I. I mean, an applicant must demonstrate that the proposed use will not adversely affect the water quality of another appropriator. And they can do so in any way, that they deem appropriate for what they want to demonstrate to the office of the engineer. And then it's on the office of the engineer to determine what that bar is. So I think, you know, one is putting a lot more, I guess I get concerned with like the all possible, water quality degradation, because I think it just fits within I. So I don't see a need to expand on that.
Well, then that to me would go to where it says potential degradation, so same thing.
Yeah, I mean, I think that fits more, same thing with that too, yeah, and I mean, if they wanna provide more evidence of degradation, they could do so under E and F when they have to establish through the tribal ordinance that they're meeting those requirements through that.
So is that dumbed down long enough to get you more comfortable, Mr. Chairman?
Well, I mean, let me rephrase what you said. I'm not trying to dumb down anything. I am-
Words on my.
I am
Thank you.
trying to be as direct and clear as we can. That's it. And I just didn't think that what we had is, and I'm not sure that does either. So I'm seeing hands here. Roger.
I guess. A standard DNRC application doesn't have anything like this. You don't submit anything on water quality for a DNRC application. But let's go back to the ordinance. To me, E and F are really specific, you know, they speak to. You know, really the F is a discharge permit, those are gonna be. A surface water application and. And the same with E, that's that speaks to their program, and I guess I would need to study that a little bit more to figure out what that is. And D is just pretty general. It's a statement in the ordinance. It's nothing as too far as saying this is part of the water right application. It just says you can't do something. It doesn't say you have to submit something as part of your water right application. So I go back into what you have. And I can kind of understand where you're coming from. If you had this information, it'd make it a lot easier for you to process it. But I think it's way, way beyond what anybody can provide. And if I was to see that in this thing, man, I could file an objection that every water right you sent to public notice will go to a hearing.
So you can still object to the criteria that are in the ordinance. I mean, just because we have policy that requires it in the application process, doesn't mean that an applicant couldn't also object to it as being absent from the proposed application because the criteria is also in the ordinance. To me, like having it in both spots doesn't like increase the chance that an objector would be able to use this water quality either.
So actually, the ordinance does say it has to be included in the application.
Okay, what does it say? I guess I haven't.
I'll paraphrase here, application for right or change use authorization must prove by positive evidence the new proposed appropriation right or change use will not adversely affect any appropriator. Then you go down to 2A. No, actually, that's a standalone.
So
Georgia,
maybe I've read this too many times and I could be reading this the wrong way. But I like to give myself examples or, just to walk it through with a mental exercise. So I was looking at this and going, okay, so we have somebody who applies, they want to take some of this water to irrigate some land somewhere on the central res, as an example. But another appropriator could be the tribes themselves. It could be tribal fisheries, right? Doing a new restoration project. That they're trying to restore bull trout habitat. In that case, it's important to understand that the original tribal water quality standards were written and criteria developed specific to bull trout. That's the origin story of the tribal water quality standards, meaning temperature and dissolved oxygen and turbidity and nitrates, all these things have to be addressed if that other appropriator were tribal fisheries. So when I looked at it that way, suddenly the burden of proof has become very burdensome, right?
I disagree,
Okay.
because I just reread that section, I just read Roger, and there's actually an escape attached there.
What, can you give me that citation?
It's 2-2-102, section 1. It says it was proved by preponderance of the evidence. Doesn't say you have to prove all possible, it says by preponderance of the evidence.
okay, but that's in there, but that's why I'm getting, you look at the proposed procedure language, that's not what it says, so that's how I'm trying to match this up here.
I think my point is, the fear we've been talking about, there's no way we can do it all, is taken care of right in that section, because you don't have to look at it all, you just have to look at the preponderance of the evidence.
So let's go back to
And the burden is on the applicant.
So let's go back to the procedure language. Scroll up just a little, so we see I, no, the other way. I and double I. Yeah, there you go. Now, required demonstrate. Full use was very. So. This is gonna be probably. Too simple in the opposite direction. Somehow we said applicant must demonstrate that they're in compliance with, and then cite the section in the ordinance. And it's their burden, they've got to comply with anyway, and stick with II. Because I don't know how otherwise an applicant can meet those other 1, 2, and 3. And I certainly don't know how our office can evaluate that and determine whether they have or haven't met. And then beyond that, it's so broad, it'd be easy to say, well, you haven't met it. Or an objector could say, well, there's no way they met any possible or potential degradation.
So I'm going to go back to my point, you don't have to demonstrate it possible.
Right, well, then we don't need this language.
We don't need 1, 2, or 3.
That's what I said too.
Thank you.
So you do need to get that preponderance of the evidence statement in the very first one.
Yeah, so let's reword it to more closely match what the ordinance says. And try to simplify this down in that way. Haley, are we getting closer?
Yeah, I think so. I had requested number 3, to be something along those lines to be put in there, because the under 2-102D, the Office of the Engineer shouldn't really be stepping into like a non-DAG analysis. And
Right,
so that's why I had 3 in there.
yeah,
Something to be mindful of, and I don't know if this is relevant or not, I'm just throwing this out there. The tribes have, and I think, I have to assume this is different than most state situations. Because the tribes have done such a phenomenal job over the last 30 years of collecting water quality data from their principal watersheds, they have a preponderance of evidence for what water quality should be in stream reaches. They've done total maximum daily load studies. They know what dissolved oxygen, temperature, nutrient profiles are, and in select reaches, what you mentioned, George, and that's the pesticide studies, right? They have that data. They have hyper accurate data, especially with regards to the needs of native fishes. So I think if a person or an entity is applying for use of this water, they need, we need to be aware of that. Tribal water quality is aware of that for sure. There's not an easy pass on water quality on the reservation.
And this applicant would have to look at available data. Which would appear to be the tribes.
And I think this is where our office needs to loop in soon, Evan Smith. And needs to be communicating with Evan's office on how does that physically work? Somebody comes in to apply to us, at what point is his office notified or not? I don't know the answers. I just think there has to be some communication.
and who notifies if it's the appropriators, due diligence, then it's up to them.
Yeah. Well, and using George's example, so the tribes are gonna build a new hatchery, well, the first thing they're gonna have to do is get a discharge permit, because those bull trout those fingerlings are gonna be pooping in the water and great nitrate loading, so then that number 3 kind of addresses that.
They
right
just
there.
poop sunshine and hope, Roger. That's what they poop.
I mean, we don't wanna get involved with it, with doing another agency's work, I guess is where
I get the water quality language in the ordinance. Question is, how do we write this in such a way that we cleanly, so to speak, no pun intended, apply it, execute it?
So I thought I heard you guys, the way you're describing it, if we could just delete 1 and 2 and pull that last section up under little I. And that would help to even to simplify, to streamline the requirements, not streamline the requirements, but to more plainly set the expectation.
And is there a way, well, there is a way, but should we also clearly reference the water quality section of the ordinance here so that it's clearly tied back to it? And
Yeah,
they can,
that would be smart.
I gotta go make a smart move right now, so.
So that's gonna be 2-2-102. 1 for the most part,
Okay.
yeah.
Maybe you just put that right after water quality provisions under E.
Sure.
Yeah, and then we have that'll, because that applies. Oh, never mind, I was wrong. So we need to do a separate ordinance section for each. Yeah, my apologies about that. Yep.
Here's my thought. I just want to underscore this. The stakes are really high on this. A portion of this is the tribal compact, the Flathead Reservation compact water, and I know it's other appropriators too, but I would hope that when we're doing this, we do create some trigger. A hardwired trigger that takes this and kicks it over to tribal water quality, and it's not just, oh, tribal water quality can't be asleep at the wheel, they have to know what's going on. Because things will get missed.
All they gotta do is ask to be on our list and they would get notice for every one of these water right. Applications that go out, and that's a requirement in all the noticing for flathead system compact water permits and changes. The noticing for those enforcement ones, change flows is a little more complicated, but that would be the way. That would be our mechanism for
That would be one way,
making
and that, I'm really pleased to hear that, I'm just anticipating. I'm picturing Evan right now, he's a friend of mine, I'm picturing him coming into work and seeing 42 of these rolling in and dismissing them because he's got 20 other things to do that day. Watch the trigger that's gonna enable Evan to be really responsive to the ones that are high stakes. That could affect West Slope and Old Trout, kind of fishery concerns, or some of these other serious concerns I have. When you're dealing with beneficial uses on this reservation that include traditional, ceremonial, and the sacred, who's watchdogging that? I know it's not our job to do that, it's Evan's, but how do we coordinate with him in such a way that he can do his job well? Rather than just hearing, hey, we sent you 42 of these application notices, the onus is on you. Who could do that, right? He's on a limited budget. And, I'll quote, Bill Sweeney had a sister, he had several sisters, has several sisters. I think it was Ruth Ann. She and I were sitting in a meeting years ago, and we were talking about endangered species. And she just shut the meeting down and she goes, you know what? This is great. We're talking about endangered species, but we are an endangered people with an endangered language and an endangered culture. And I think when you're dealing with water and you're dealing with the rights of Native people, you cannot separate those two things. Right? You just can't. And when we're dealing with water and water quality, we're getting to the beating heart of a lot of needs that Native people have here. Now, I know that's beyond the scope and purview of why we're here, but if we've got water quality baked into an applicant and an application, we need to make sure we're helping those whose job it is to really take a look at this. And I think that's part of it, Ethan, and thank you for sharing that. Getting that to Evan is part of it, but I think we can do better than that.
So if you look down at sub 2 and 3. Okay. We have the opportunity to request the applicant obtain written verification.
Okay.
Or so, that would be a mechanism you might consider. Or but that is beyond notice. That is a positive requirement for the applicant to go interact with the Tribes Water Quality Office. Whether the board goes down that road or not, you'll have to tell me. I wrote things broadly here with a lot of options for you, so you can pick and choose a smorgasbord of what you wanted to do on what I consider to be a fairly complicated matter.
Yeah, and as complicated as it is, I think that 2 and 3 probably goes a long ways toward trying to help solve that. Going up just a little to where it says number 1, the OE will not evaluate that paragraph. that was number 3 before. Haley, you said that's one you wanted in there. Talk us through that paragraph.
Yeah, I mean, so Ethan actually was, he went into what I was exactly gonna bring up, so I could give a little bit of clarity to maybe George's concerns. So the reason why I wanted 3 in there was because Ethan and I talked about adding in this requirement for applicants to get written verification from the tribal office, specifically about water quality, before the engineer's office could even evaluate the application. And so the 3, which is now 1, was essentially to say under that 22102 sub D, that the Office of the Engineer does not need to essentially evaluate water quality to the extent that the tribal offices do. Because if the Office of the Engineer were to require that specific like non-degradation or non-point source information, they would request the applicant to get that from the offices who are much more technically savvy and have the information available to them to provide it to the office.
May I add something?
Oh, Ken.
Clean Water Act, so unfortunately I litigated this one and lost. As this 401 section. Where applicants are required to go provide certification to the issuing agency that they've met all state and tribal water quality standards. Is that something we could think about using here? I mean, kind of going in that direction.
Going in with 2 and 3. So. Really, let's keep talking about that, but I wanted to, Haley. So the phrase beyond the direct effects of the proposed water use. What does that mean?
You'd have to ask Ethan that question.
So, Mr. Chairman, board members, my intention here is to not try to regulate the application of herbicides or pesticides or other indirect contaminants that may be associated with the use of water. Instead, our focus would be on just what the application of water does. So if the water goes on to hot ground, laden with soil, that is fine, and then runs off into an adjacent source, that would be a direct effect of water application. Right? The things I don't want to try to get into that are not anything that we have any skills or charged with. I think from the ordinance is like, if somebody's using pesticides or herbicides, I mean, it's not our job to evaluate that aspect of it. Unless you want us to, and then this section is going to be a lot longer.
No, I don't think we're asking that.
Sure. That's the intent of what that statement, which may need to be updated, but that's the.
Oh, I'm just asking for clarification. I'm
Oh,
not-
yeah, sure.
Can I change anything yet? Ken, your further thoughts on 2 and 3? And do they meet what you're thinking, or?
Well, 2 troubles me a little because it says federal clean water act administrator, and it could be, written verification. Because tribes don't have TAS authority over. Right, I mean, point source. They have authority over non-point source.
So the 2 and 3 are directly from the ordinance. The only thing that Ethan and I added was the request to the applicant to obtain written verification. But
And that's-
the actual language in the section cited there for the Clean Water Act, and then under 3 for the tribal ordinance, those are specifically within the ordinance and are required for this type of application.
To get to your point though, Ken, it gets a little fuzzy While the tribes do not have treatment as a state status for section 402 of the Clean Water Act for NPDES, the EPA writes the permits using the tribe's water quality standards under section 303, which they do have treatment as a state. That, I guess, one other thing, may I
Go
share
for it.
something? Under section 2, may I request that we coordinate with Rich Jansen, the department head at Natural Resources, Chauncey Means, the division manager, and Evan Smith, a little bit on this language before we formally adopt it? You know, I don't want to, I don't think we are in a position to speak for them on this. I think we need to give them an opportunity to,
We need to coordinate.
we need to coordinate with them on this, because like I said, the stakes are high. And this directly affects them.
Well, they've got a job to do. They're gonna do it. The question is, how do we do our job in coordination with them so that in such a way that we're not turning you guys into water quality specialists, we're water rights specialists. The question is, how do we make this work and how do we make it apply?
Perfect.
Yeah.
For what it's worth, I mean, it's not like that language ended up in the compact without.
I know it
Right,
didn't.
without.
Oh, no, I can't imagine there was no debate.
I want to say that it's not, there's been some input into the requirement in the first place. I do think that, you know, noticing draft language is a great way to get a response.
Yeah, and then on 2 and II and III, it looks like the option is built in when it says may request. So that means you may or may not, right?
And it doesn't say that we would necessarily take any specific action after, you know, in response to that request at present. It is something I'm kind of going to ask you about. Yeah.
Well, I think everything we're doing here though is just simply to determine whether or not we can agree that it complies enough so that we can issue a water right.
Yep.
Roger.
I was gonna say, maybe when you coordinate with them, you can ask them if you want those 2 sentences in there. The OE may request that. You know, to me, it's not necessary, because if I'm applying for a municipal water right, I'm not familiar with those, but I'm not gonna be discharging to a stream or something like that. It's going into the water system, and I'm just gonna write in the application that this, we don't have this, we're not regulated under this
Here's, let me just
permit or
throw
this law.
sort of a question and slash thought out. And following on George's thoughts about the office, the water quality office. So aside from all of this, a water right appropriator doesn't necessarily go after a water quality permit. They don't try to comply with water quality regs. So while we're trying to comply with the ordinance, what if we just sent notice to them and then it's between them and the applicant? And if they decide the applicant needs to do something water quality wise, they can do it. Maybe that's not right either, but that's a thought. And then, you know, even with this language, we may require them to provide more information, but if we just provide that office with notice, application comes in, we just send them notice, application came in. We keep doing our thing, and then if they decide they need to reach out and do something for water quality purposes, they can do it. If they do it, they do. If they don't, they don't.
if we took your approach, then maybe what you say. Or we will not evaluate water quality consideration, but rather will forward it to. The regulating agency.
Well, it's a thought. Now, my question then would be for Haley, would that comply with the ordinance enough? And I think the question is not only for us, but for the public. And would the public object and say, well, you're not complying with the ordinance? Who's gonna object and just complain that we're not complying with the ordinance if we don't do something more?
Well, I think another way of looking at it, if he wants a third level regulation.
So with what you're just writing in now, what the DNRC does is they'll send their public notice to some of these agencies and let them decide if they wanna provide input or not. And they do that with other, subdivision or applications or conditional use permits or something. They'll send it to they might send it to the health department. They might send it to the road department and ask them if they have any comments, as and let them decide.
The issue I have a little bit with that is that this is under this sub 2, which says specifically, okay, for any application for the appropriation right or change that is not, yada yada yada. The board, engineer, or designee may modify or condition the issuance of appropriation right or change in use authorization applied for to ensure that. And that's where it says the proposed use will be consistent with the classification of water set for this source of supply pursuant to the water quality standards under the Federal Clean Water Act. So my point that I'm trying to make is that we can't necessarily condition something. We would be issuing something absent that ability to condition if we just rely on a notice.
Okay.
Which I mean, personally, I think you set that out in the policy, if that's what you're gonna do. That is an approach that could work, but do think about that. There's this notion here that we would modify or condition an issuance to assure these general 3 items, on that.
Yeah, like I said, just a thought.
Just playing devil's advocate with myself. When you think about the long scope of the tribe's water quality program, for most of its existence, since it got started in 1989, they had no say in any water rights on the res. So the fact that there is a notice procedure, an on-ramp for their comment, that's a powerful new tool that was never available to them before. So that's helpful. But the caveat, I'm playing both sides of this right now. The tribal water quality program is not like some state programs, right? That gets funding from all over. It has very limited funding. And so while this is great that there's going to be a comment process that they've never had before, if we go that route, there's limited staff time to do it.
So I just noticed in reviewing these rules, and you can check this, Ken, under 2-2-102, and then you go down to 2E, your language under 2 and 3 back in the policy See, it says the proposed use will be consistent with the classification of the source water supply. And then the other one says, will not impair the ability to discharge permit. These are very specific language. The language you put in the policy is more broad. I think if you can, you know, yeah. I mean, to me, these are very easy to comply with. Well, not easy, but I mean, they're doable. This is too broad, too all encompassing, it seems like. Maybe you need to go back to the ordinance and use that language.
But let's go back to that ordinance language again, that's before we do that, and just let's unpack that. The proposed use will be consistent with the classification of water set for the source of supply. If you, I'll tell you how I read that, the source of supply is either gonna be Flathead Lake or the Flathead River, which is either A1 water quality standards or B1.
Or any appropriation, right? Any
Yeah,
new
any-
appropriation.
Yeah.
So it's anywhere on the res.
So it's not just the Flathead compact.
No.
That's what I keep defaulting to. Okay, that's where I'm.
It is under this section right now, but the language that you're gonna choose here will go also under the change in new permitting sections, so.
But it could mean Flathead Lake and Flathead River,
And-
meaning
In this first set of policies, it does mean.
A1 water quality standards and B1 water quality standards, which is like drinking water in most of the United States. I mean, some of our lower quality water here is better than the best drinking water that you're gonna get anywhere in New Jersey. Sorry for anyone in New Jersey who might listen to this someday, but that's just the truth, right?
Yeah,
So that's what you're asking somebody to comply with there.
well, the other thing that we really haven't touched on, and it's probably gonna be more of a rare event. But everything we're talking about implies surface water. Water quality could come into, I mean, groundwater could come into play here too, not just surface water. Could a groundwater use have a effect on surface water quality use?
Okay. Now this gets really fun. So Scott's sitting over there. So Scott, you're gonna hear me rant just like you did in class. Okay, so under the prior administration, the definition of waters of the United States got changed and it's being worked through the courts now. And Kim, you could educate me on what that means exactly. But since 1973 until the last administration, waters of the United States included interactions between ground and surface water. The last administration changed that definition and took away all interactions. The place where that didn't occur, that change in definition didn't occur, was in Indian country. So on this reservation, on the Blackfeet Reservation, on the Northern Cheyenne Reservation, these are all reservations I've had direct influence involvement with their water quality standards. The 1973 definition of waters of the United States is retained in Indian country. Meaning exactly what you got at, that ground and surface water interactions are protected under the more stringent language from 1973, so. That could.
And then there
have a
are two kinds of interactions. There's natural interactions between surface water and groundwater, and then there's wells
And then there's wells.
and spring development. Yeah.
By that, to me, that like it's.
And
not-
there's seepage from the irrigation lines that,
Not to throw too many wrinkles into this.
so,
I guess to provide a little bit of clarification on that, The compact does make a distinction that the flat system compact water is direct flow water, right? So it would be surface water. And then there's controlled groundwater management areas specifically within the ordinance that pertain to the groundwater standards that might be within like the tribal ordinance.
But no appropriations could be surface water or groundwater.
Are there ever instances where a new appropriation would be a shallow groundwater well, like for stop water? Because that would imply that really strong interaction between,
Oh, I mean, like I said, we'll see. I mean, physically it could happen because there are plenty of shallow groundwater sources here.
so under state, just. Under the state, that would not be a water of the United States, under state law. But under tribal water quality standards, it would be. And it would get all of the full protections that the Clean Water Act provides.
As I'm rereading E on the ordinance, I actually think we could eliminate the fall under the Federal Clean Water Act and just rely on, because there's that and contained in regulations promulgated under the 89B. So we could just default straight to the 89B.
There's a good parallel between our ordinance and that one because they both only apply on the res, correct?
Yeah, and the tribes is more stringent than
Right.
federal.
Well, I'm just, that removes, so if you go back to the language, it just goes. So I think on my reread, I could read that to just delete. No, yeah, double I. Yeah, I mean,
And you could add a caveat here, an applicant is required to adhere to water quality management ordinance, Tribal Ordinance 89B, which must be at least as stringent as the Federal Clean Water Act. Section
I think that's more than what the ordinance is saying. It was and is promulgated, you know, by 89B. So if they were to choose to promulgate something less stringent, that'd be the tribe's call in ordinance 89B or subsequent updates to it. So I think we could, which I really like that because it gets us away from having to send somebody to this nebulous federal regulatory institute. Which is not easier on Evan's office, but it is, I mean, at least you can find that office.
So, are we following the ordinance 89B or the standards? Was it-
Those are synonymous.
Then I would say comply with.
We should check that though.
Comply with.
Maybe, is there? As a placeholder until we know for sure, could we put comply with water quality management ordinance, Tribal Ordinance 89B and the CSKT water quality standards?
Right, we're gonna have to come to we're gonna start hitting our brakes here for the day, unless you guys wanna go longer. But I'm not so sure, I mean, are we far enough along with this that we're okay, or Haley, do you need to put more thought into this? And I'm really asking because I think the Flathead Reservation Water Management Board is trying to adhere to what the ordinance says on water quality. So we've got the ordinance language. These are the procedures. I suspect whether procedures language or not, at some point, someone's gonna have a complaint about how we handle the water quality portion. And that complaint could go a long ways, but in the meantime, we need to really rely on your best advice on what language we put into these procedures. So while we can hit pause and leave this for the day, just encourage you to take a real hard look at this, and if you have other recommendations about how we might phrase any of this section for water quality purposes, please advise. So if not today, soon.
So. I'm sorry, Neil, go ahead.
No, I was just gonna say, I can have, I didn't take, really. I didn't really put in a whole lot of language into this section, I just kind of provided some feedback. But hearing all of the conversation that's happened today has really informed and provided me with some really good thoughts. And so I'm happy to provide maybe some more detailed language and direction for the next meeting.
Would be good. Would be good.
I guess my closing thought then, Haley and others would be, there, as I look at this and as I listen to what everyone shared today, it seems like there's multiple definitions of success for this section, right? One definition of success is that an applicant can have a very straightforward understanding on how to apply for a water right. Another definition is that our office can issue that water right straightforwardly without getting into the business of another managing entity, right? And the third definition of success would be that we set this procedure up in a way that we are being protected with water quality to whatever degree we can be. But those are all three really different definitions of success that we're trying to accomplish in a very small section.
And they're all compatible.
It's challenging.
Um,
Did I capture that well?
Yeah.
Does that sound right to
Yep.
everybody?
that's good. That's good. So we don't really have any action on this at this point. Is there something we need to take action on?
I think you moved the ball on some items, Mr. Chairman and board members. And appreciate your attention to these matters, and really keep plugging away at it at the next board meeting.
Okay. We have public comment, next meeting and end meeting. While it's not specifically on the agenda, going to ask for any final comments from board members. Anything?
I would make a comment, I thought you all may be interested, I took a hard look at the water law conference. They're gonna do a whole section on groundwater receptions, groundwater case. It might be really, if you want, you can just go to one section, not to pay for the whole thing. But I thought that'd be really relevant.
Good. Good.
Thank you. I'd love to.
Thank you. George, anything? Georgia,
I'm good.
Roger?
I don't have anything. I think, I have two things. Didn't the DNRC offer to put on some kind of other course too?
Thursday of this week. We have, it's not really a DNRC course. We have a meeting with Melissa Brickle, and she's gonna go over the current procedures for determining physical and legal availability and groundwater modeling and the other relevant hydrometric type activities that are going on for permits and changes off the reservation, so that we can better inform ourselves as to what our options are, what our needs are, and, you know, try to move the hydrometrics portion of permits and changes forward out of our office.
What time is that gonna be?
I did send you the invitation,
Yeah, I know.
and I did solicit you were the only one who was interested. If anybody else is interested, that's 9:30 to 4 o'clock.
Oh, geez. Okay. Okay,
That's arduous.
huh?
That's arduous.
Yeah, that's a long step, yeah.
There'll be a lunch,
Okay.
break, lunch break. No. But,
My other comment is, I guess we moved the complaint process along pretty well today. It looks like you about ready to go on that. So that was number 5 on our priority list, so we can kind of scratch that one. That takes us back up to the top of getting back to then the new appropriation applications and municipal, specifically municipal applications. And previously, when Arnie was on, was whatever his role was, he had offered that Attila Fogarty, who's the DNRC hydrogeologist and has done groundwater water right applications for probably 10 or 15 years now, could assist you guys in preparing the policy portion of that if you're interested. And Kayla has consented that this same offer is out there with her if you want to coordinate and bring Attila in to, work as a team on that. So he's got lots of experience and it might help you.
Attila was part of the coordination of this Thursday meeting for,
Well, yeah, but this is specific to your next step of the municipal groundwater application.
Sure.
Policy and procedures manual. So anyway,
Excellent.
offers on the table from the DNRC.
Wonderful. Appreciate that.
And I just had a couple quick ones. One is, I realized it was short turnaround between our last meeting and this one. But we also set a pretty high priority on the budget. So we want to make sure by the time we meet again, we've got something to look at.
Sure.
We talked about that, so appreciate that. And then I have one more item, but I've got a text message from the lady who does the cleaning on the offices here, Zetra. Now, let me just pass this around. I don't want to read it because there is a little bit of personal information in here that I don't want to share publicly. But the bottom line is, she's giving up cleaning job at the end of July. And so unless you want her to provide another written formal notice, this is her notice, but let me just show you what she had to say. It's real short, but there's a reason the personal reason that she's stepping away. But anyway, she's given notice she's gonna be done after July, so we'll want to try to find someone to replace her, whatever process we need to do to to replace that if you need it.
Oh, I had just another question. Did you get back with the landlord and negotiate the lease or whatever was the status of that?
I'm sorry, what?
I said, were you able to coordinate with the landlord and negotiate the lease extension?
She is in Yellowstone, for a little while, and then I will keep trying. But, the noise, oh, sorry.
That's all right.
The noise that, you heard is the beginnings of the installation of the air conditioning, so. That's a step in the right direction.
So anyway, bottom line is she's giving up her cleaning job end of July, so we'll need to find a. We need that service, we'll need to find a new service for that, so. Just wanted to make sure everyone knew that.
Thanks.
Any final public comments? No public here in the physical audience, anybody online?
If anyone online would like to make a public comment, raise your hand and we will allow you to. I'm seeing no public comment on.
Seeing none, hearing none, so. Next meeting. Our next meetings. Did we have another one? So we were into July then?
The 10th.
10th and 17th, 10th and. So we're looking at the July 10th and 17th, so. Folks still good with that? So far, so good? Yep, okay. Lots of head nods here. I might be falling asleep here, but that's lots of head nods. Thank you all. Motion to adjourn.
Motion to adjourn.
Motion, second, all in favor? Aye. Okay, any opposed? Who's opposed? All right, thank you all.
Thank you.
All right, guys.